the important things on front.
Paper. Oh, yeah. I hit unmute. There's a over there.
Good morning. And good morning, remote. If you're joining us remotely, I know we have at least 130 folks on Zoom with Last Report, and we have a simulcast going on YouTube as well. So thanks for joining us today. My name is John Walls. I am the Chief Counsel for the Advisory Division at the Attorney General's Office, and we have been gone from this activity for a few years, and we're very, very happy to have it back again and start this back up. And we trust us, we heard from many of you that we know you were really wanting us to get this back up and going again. So we're happy to do that. Very happy to have the other agencies that are co-presenting this material along with us today. Obviously, this could not happen without all of their input and all the cooperation. So IDOA, SBA, we have special guests from IoT, and the Inspector General's Office as well. We have a very, very good program, I think, for you today, and it's packed. It's really packed with a lot of information. Because of that, I can't promise you that we're going to have a lot of Q&A time because the material is that robust and we have that much material that it's important that we get through. So if you have materials, you will see not only in the things you've been sent, but also today in the materials that you have. There is contact information for each and every one of our offices, and we're more than happy to field those questions if you have them. So save them if you don't get a chance to talk to us today about that. And we will do our very best to make sure all of those are answered, and so that we clear any questions you have or confusion you have in your mind. So a couple of other housekeeping notes. We have 2 15-minute breaks in the agenda, if you've looked at that. And then the final segment today is going to be Inspector General and a little segment on executive branch lobbying. So some folks, because they may not be getting CLEs if you're not a lawyer, sometimes don't stay for that. I would encourage you to stay for that. 2 reasons. One is, if you don't know about executive branch lobbying, you need to hear about it because it affects everyone, and a lot of people don't really understand what that is. So I'd encourage you for those purposes to make sure you listen to that. For those of you who are seeking continuing legal education credits, this form was handed to you if you're here live, which is the certificate of attendance. You can fill that out while you're here. Hand it to us at the registration, either throughout the presentations today or when you leave. You may also email that to us. That's fine. Actually, it's probably preferred to the same email where you got the information from us on the program to begin with. And if you're remote, again, print that out. An email is going to come to you with this certificate when the seminar is over. Fill that out, get it back to us, and we'll make sure that we get your credit. One thing I will tell you is you have 30 days, hard stop, 30 days to get that back to us, or you're out of luck. You have to deal with CLE folks yourself. That is the deadline, so make sure you don't forget to do that. We will not be chasing you down for that after today. It's on you to get that back to us, so please do that if you want your credit, and I'm sure you do. So today we're going to start off with State Contracting 101, and we have some very fine presenters from Department of Administration. We have Tammy Glickman and Aaron Kellum, and then from the Attorney General's office, Bill Anthony and Philip Gordon will get up a few minutes later and speak to you on that. So it is my pleasure to invite Aaron up to the podium to present. So thanks.
Good morning, everybody. It's good to be back because I need my CLEs. Okay, I am supposed to do the clicker and I can point it anywhere. There we go. Where do I even begin? Wait, these aren't mine, are they? These aren't mine.
Preliminary ones.
Oh, okay, sorry. We did a run through. Could you imagine how messed up I would be if we didn't do the run through? Okay, so that's me. Tammy Glickman is sitting right there. She'll be presenting next. I'm the Director of Procurement. So my team is in charge of purchasing for all state agencies. I'm sorry, executive branch agencies. Really, we did practice this. Okay, I've got just some general slides because I want to kind of sort of set the stage for what we do. As you see in our mission statement, we see all the executive branch agency as partners. We are your partner in your purchasing and procurement solicitation endeavors. Bring us in. We're happy to help. We're not trying to get anybody. We're just trying to get you to where you need to go. And the sooner you bring us into the whole process, the more helpful we can be and more cover we can provide you. Guiding principles, what I wanted to highlight here is the impartiality and transparency. What we want to make sure with our process is that any vendor that engages in responding to a solicitation understands that the process is neutral. We want the best respondent, provider, vendor for the state. We don't have some hidden agenda in mind where we're trying to make sure this company gets it or this one doesn't. It's not how our process rolls. We also, in order to preserve the integrity of the process, much of our process is transparent. So the responses are public records. We do have some parts of it that are deliberative, so you don't have to worry about your scorecard being shared with the vendor community, your notes, or even your identity. We keep that stuff confidential or non-disclosable to make sure folks feel comfortable being open and honest during the process. But the rest of it is open. Everything we do at IDOA is set out in statute. As you can see, there's a lot of stuff. There's a lot of stuff. And my team's over there with procurement. Where do you start? We have a lot of information on our website. So bookmark these pages so that you can refer to them. We have a lot of CBTs, self-led CBTs online, so you can refer back to them when you have questions, and we've chunked them up into small doses, so you don't have to set aside, 2 days of time to refresh your memory. You hear the term DPAP. That is a training program that every head procurement agent has gone through. If you don't know who your head procurement agent is, find out. They are a wealth of information. If you are the head procurement agent, yay, thank you very much for the work that you do. We appreciate you guys toeing the line and helping to make sure everything is done as it should be. Everybody gets money from the state budget bill, but you don't actually have any legal authority to spend it until you come to my shop. We have delegated authority to executive branch agencies under $75,000. That's where DPAP comes in. That means that the head procurement agent has gone through the DPAP training and has been certified that they know how to follow the procurement rules, statutes, and policies, and that any purchase made under $75,000, they'll oversee and make sure it's done properly. DPAP manual is what lays out all of that. So if you go over $75,000, then you come to my shop. When you think about procurement, it's just, you're buying something. That is what you're doing. But there has to be a valid procurement method underlying every purchase. And that's to ensure that there is open competition and that every vendor has the opportunity to get state work, because it's state tax dollars that we're spending and we pay our bills. So we are not a customer usually that you have to chase. So vendors do like working with us. We pay our bills. Here's some examples of different types of procurement methods. We've got this statute up there so that you can read more, because set out in statute, there are certain steps that have to be followed if you're using one of those methods, and certain limitations, like negotiated bidding, there's a dollar limit. Request for proposals, there's not a dollar limit, and that's where a lot of services, basically all the services, if they're over $75,000, that's what you'll hear. That is really our bread and butter of my team. It is the RFP process. Here's just a bullet point of what the RFP process involves. Again, it's over $75,000. Please note the entire process can typically take 9 to 12 months. I know that sounds like a lot, but if you've not been involved in it, I just need you to understand it really does take that long. And it's not just because my team has so much work to do. It's because, like us, the vendor community has some vacancies. They've lost some people to the Great Resignation and retirement. And we are hearing more and more since the pandemic that the vendor community needs time to respond to the RFPs. If you've ever read an RFP, they are robust. And it takes a long time for the vendor community to respond. And like us, they have other things that they're doing. Responding to an RFP is not the only responsibility of their job, because frankly, it doesn't make their company any money. They don't get paid for submitting an RFP. The state doesn't pay you for answering an RFP. So they need time to read it, digest it, make sure that they provide us a quality response. Because if it's not quality, it's a waste of their time, it's a waste of our time. The only time frame set out in statute is 2 weeks. We've got to post it in the newspaper. Yes, I said newspaper. We still use it. So we have to do that. That is set out in statute. The other thing, as I mentioned, leaving it on the street 8 to 12 weeks, that's not what we used to do. It used to be on the street about 6 weeks. And inevitably, we would get requests, overwhelming requests from the vendor community. Hey, can you extend it another 2 weeks? Can you extend it another 2 weeks? Or if we said no, we'd get the responses back and they weren't any good. And so we had to go back for clarifications and clarifications and clarifications. And we ended up about at 12 weeks anyway, before we finally got a quality response. So please bake that into your process. I'm not interested in you guys reading hundreds of pages of crap. That we don't have time for that. So we need to give them time to respond. Special procurement / sole source. That's not the same thing, but that's what people call it. This is a pretty popular option, but I need to caution you. It is legally valid. You can avoid competition, quote unquote, avoid competition, but it is very fact specific. And you can throw hypotheticals at us all day long. Well, what if this, what if that? I don't know. I don't know. Hypotheticals are not where the law lives. We live in facts. So if you have the facts present to justify using the special procurement code, great, we'll approve it. But you have to tell your story. Think of, let's say your beloved family member owns a business that provides whatever services you're trying to procure through a special procurement. Would your beloved family member feel jilted that they didn't get the opportunity to compete for that state business? If you make your case, then no, because the facts present indicate that this is why we have to go this route. We see a lot of sole sources. Again, that's not really the best one because that's for supplies only. It's been misused over the year for services. It's not what the law says. That's not an option. So you're going to have to look to the other sections of the code if you've got a situation where, well, this vendor created this database for us and they're the only ones that can maintain it. Okay, that's a service. That's not a supply. So talk to your lawyers, talk to your head procurement agent. You can call us. Again, we need specifics and facts, and we can try and walk you through the process. Keep in mind too that these are highly scrutinized. We always prefer competition when we're spending state dollars. So my team's going to look at it. If we don't understand what you're doing, we're denying it and sending it back. If somebody on the street were to read it, just think about it like this, would they understand why you're making the purchase this way? So far, they're not public documents, but act like they are, because my personal opinion, I think someday somebody's going to make a valid enough case that we're going to have to disclose the special procurement. And we shouldn't be afraid of doing that because it's going to be well documented and explained. IoT also looks at these. So does SBA. Everybody's got a different lens. Obviously, my team's looking from a procurement standpoint. IoT is looking from how is this going to impact IoT projects as a whole? Will this require IoT resources? And budget, they're worried about money all the time. We now have the electronic public or special procurement process. It's a lot more efficient than the emails. It is so much better than the emails. But as you can see, so far, just the beginning of this month, we've done 695 of them. That is huge. That's 695 could have been RFPs. So we know that there's a lot of federal dollars out there that are coming fast and furious, and you've got tight timeframes to turn it around. So I'm hoping this trend doesn't continue because they're a lot to get through, but it is a lot more efficient, and we insert IoT and budget in the process. Now let's sort of shift gears a little bit to what many of you have known in the past as MeeBee-Weebii. It now includes Indiana veteran-owned small business, IVOSBs. So it is DSD. I know, I love the alphabet soup of state government, but is the Division of Supplier Diversity. So it includes minority certified businesses, women certified businesses, and again, veteran-owned small businesses. Keisha Rich is the new director. She is knee-deep in all the activities of Black Expo this week, as is her team, so she sends her regards. They have several core functions, which is certifying the businesses. There is extensive verification that it is in fact woman, minority, or veteran-owned. They do contract compliance and then business outreach to help the community know that this program is available and how they get certified. We also have goals. I'm sure you guys have all heard of this. These are statewide goals for each of the different categories. These goals are come up with as a result of a disparity study that's done every 5 years. That is required by the Supreme Court case that kind of gives us the guiding principles for how a state can run a program such as this. And then there is a commission that approves the goals. Again, they're goals. They are not mandatory or required, but the state does track them and we try and meet these goals every year. So contract compliance, this is where the goals turn into something more. Part of Keisha's team verifies that the commitments the vendors have made during the procurement process are actually being met. So when I talk about an RFP, it's the easiest example to provide. There are points in the RFP process that are given to vendors, respondents, who pledge to use minority, women, and/or veteran-owned businesses. Our RFPs are very competitive. So sometimes it can come down to those points. So if you've committed to a certain percentage to a woman-owned business in your RFP proposal, you vendor are held to that in your contract. So that percentage, that specific business is named in the contract and you are responsible vendor for working with that particular subcontractor at that percentage. That's where vendor contract compliance goes in. They have a system to check that and to make sure that that is happening. Because again, it was a commitment in the RFP, but then it becomes a contractual obligation when that RFP is then turned into a contract. So if a vendor needs to change any of that information, they've got to go through DSD contract compliance. I do not have the authority to grant a vendor permission to change their percentages or their vendors.
Neither do I.
Neither do you, neither does the vendor. It's only DSD. And it doesn't matter, we hear this all the time, but the overall percentage remains the same. I don't care. What you committed to was a specific percentage to each category of certified business, and you committed to specific businesses. I didn't make you do that. You put that in your proposal. You got points based on that, so figure it out. If you can't figure it out, talk to DSD. They're reasonable, oftentimes much more reasonable than me. So if there is a valid business reason, they will work with you, but you have to work with them. This is where people get tripped up a lot. If you're doing an amendment to a contract, there's words on the amendment template that talk about what's happening with the subcontractor commitment. Folks just erase it and move on. Don't do that. We're trying to help you out. Based on this administrative code, you have to address what is happening with the subcontractor commitment in the extension or the amendment. It may be a case where the subcontractor was part of the implementation and you don't need them going forward. Talk to DSD, get their approval on that and provide that to Tammy when you send the contract amendment through. Otherwise, she's going to stop it, and this is why. So again, DSD is your friend when you're trying to change any contract, any subcontractor percentages. All right, now I turn it over to Ms. Tammy.
Hi, good morning. As Erin said, I'm Tammy Glickman. And pardon me, I get the pleasure of talking about templates and all of the nitty gritty that we do every day that you guys are all doing in your agencies at different levels. So of course we have templates for everything, and that's because we do so many of these documents across all state agencies. And I will tell you that even non-executive branch agencies use our templates as a base moving forward. I've heard that from some folks in my time at IDOA, and I think that's really something to remember, that this has been drafted over the years. We try to improve it every year, as well as our lease templates based on updated laws, of course, and input from everyone. So please do send suggestions, statutes. Sometimes we miss them. We update our statutes. those sorts of things. We truly appreciate all the work that you do as you look through them and send suggestions to us. Here's the links where you can go for those. I did want to briefly talk about fleet and travel later on, so that's why that's up there. So here's the numbers. As you can see, we're close to about 10,000 contract documents that we approve at IDOA every year. At IDOA, I'm the Deputy General Counsel. We have a General Counsel, John Sneathen, and Sandra Redding. Those are the only 3 people that approve 10,000 documents every year: grants, amendments, renewals, contracts. That's a lot of work for 3 people. So your help in using the templates and documenting everything in SCM is greatly appreciated, or we could never get to these numbers each year. Just a quick note on paper documents. Sometimes you will need to use a paper contract, a paper amendment, a lease, and that's okay. When you do that, you have to default to the old way of doing paper. It needs an EDS sheet. It needs the original documents attached in paper. It needs, of course, the clearances in paper. You need your procurement method. And all of that will come through the routing process. I want you to know that Sandra Redding is so conscious of where these documents are, but we do not keep an electronic record of them. So once we approve them and they move to state budget, they're routing through our courier. So we don't have the electronic record that we used to have. So you may know, these are our elements, I guess, that we review, and I'll just go over them pretty briefly. The most important thing, as Aaron said, that we're looking for is your procurement method. If it's a contract, a grant is a little different. A grant doesn't need a procurement method from IDOA. Those are managed by the agencies, and we are not looking for procurement on a grant. But when a contract comes through, whether as an addendum or a professional services contract or any other name, the heading at the top is helpful, but your written agreement with a vendor is a contract. And when I read it and I see that there's services involved, it doesn't matter if you've just called an agreement. It's a professional services contract. And so I'm going to look for a procurement method. So make sure your procurement is well documented. I'm focusing, of course, on what are the duties? What did you purchase? Can I understand it? Do you have the consideration there? And I'm looking at your procurement method. So I open your procurement method up first, and then I look at your contract. And if the dollar amounts don't match, I'm asking questions. If I can't tell based on the duties or the services that are provided that track what the procurement department approved for you, then I'm asking questions. All of these things are going to slow down your contract. I can say that it is, we're approving contracts at IDOA in 5 days or less. So those numbers are pretty impressive that we're approving all these documents in 5 days or less. So if you have everything in there, that's going to speed it up. Of course, if you use the template and if you document everything in section 50, as well as your grant, there is a section in the grant as well that says, here are the places I changed. It's difficult. It's very easy to scan an electronic contract for words. That helps us. And I'm sure my other approving agencies will address that as well. But when you've scanned a document in, which many of you do, and you put it into SCM, I cannot scan that PDF version of it for words, for changes. And so I just have to go against the standard template to find out what was changed and whether that impacts my ability to approve the contract without further questions. So what might delay your contract? Everybody wants it to get through quickly. We're all very, very busy. I mean, I'm doing 10,000, but you guys are probably doing 3,000. And there's probably 2 people at your agency also. And you may only have 1 attorney. and one procurement agent. So you are pushing it to the deadline many times. We just finished fiscal year. There was a boatload of things that needed to get, logged into last year's fiscal year. And then there was a boatload as soon as they opened up the checkbooks again. And everyone wants to pay their contractors. And we want to help you do that. But if you, of course, if you use paper contract, that's going to go much slower. Everybody knows that. So, but if you have everything there, it'll go faster. The number one thing that will slow down your contract is your procurement method. A lot of folks forget about it. I don't know. Even an amendment needs to have some documentation of procurement, whether it's in the original documentation or subsequent. And of course, if I don't see it or if there's insufficient documentation, then it's going to slow down your contract because I'm going to have to email you and ask for that. And of course, if you don't have your clearances or there's insufficient amount of clearances. So a lot of people ask me about a checklist. Tammy, why don't you put together a checklist? If we only had a checklist, that would help us to make sure everything was there. There are checklists. And there's a checklist in the DPAP manual, and there's a checklist in the contract, the professional services contract manual. And I'm happy to add other things to that if you have suggestions, but there are checklists and you can print those off. So those are available. Okay, so let's talk a little bit about clearances. Are required, and I've put the statutory requirements and the contractual requirements. These, and people ask me, well, why do I have to have that? Why do you care? I care because if you haven't paid your unemployment insurance for your employees as a vendor, or you haven't paid the Department of Revenue your taxes in the state of Indiana, then to me, and perhaps to you, it seems absurd that the state of Indiana would now fill your pockets, you vendor, with more state dollars when you're not paying us the things that you owe to the state. So those are the tax clearances. And then of course, the Secretary of State requires registration. There's the Indiana Code. And the Secretary of State requires registration for vendors for doing business in the state of Indiana. That term is defined in statute. There are exceptions. Gosh, there are all kinds of legal things that the Secretary of State's office does that I don't understand. And I can't offer you that guidance, I guess. And if anyone here has called the Secretary of State asking, vendor X isn't registered, do they have to register with you? IDOA is demanding it. You may not get a call. They're very busy over there too, and they don't offer that kind of guidance to vendors around the country. So I'm asking you to do the research. And if you've made the determination at your agency that this contractor is not doing business in the state of Indiana or falls within one of the exceptions, please document that. I don't know that your general counsel has determined this vendor is not doing business in Indiana under this contract. If you have, load it into supplemental documents as a Secretary of State clearance, and that is sufficient for IDOA. Of course, we don't want suspended vendors or debarred vendors to be doing business with us. And that's a contractual clause, and the federal government has debarred certain vendors. I think we all know them because they're stealing data from the United States. Okay, so contract drafting, it's an art. Contract drafting is an art. So we have a template to help you, and that gets you started, but you can be creative. And what I'm trying to stress with this slide is that, like a stool, there are three elements of a legal contract: offer, acceptance, and consideration. So when I see a contract that says, number one, duties, number two, consideration, there is no consideration for this contract. I immediately think the stool's tipping over. This contract is not a binding document because there is no consideration. But what you really mean is that there aren't any state dollars that are going into this contract. But vendor is giving services to the people of the state of Indiana. They are then billing my contractor, who is not taking any money from my state agency, but they are taking money from the insurance company or from the vendor for these services. So explain that. Sometimes it's just the mutual benefits and the mutual benefits of the contract. Sometimes we have interns and we're not paying them. We're getting the benefit of the intern, and the intern is gaining experience. So explain that there and keep our stool standing on all three legs. People ask, can I ever, and many people who've, been to these seminars before, been in state government for a while, they know they can make changes, but some people think they can't make any changes to the template. And you can make changes to the template, especially if it serves your business need. You've done a robust risk assessment with your legal department or your chief of staff, executive members, and you have documented it well. So obviously you're going to change your duties and your consideration in every contract. But let's use insurance, for example. We've listed the tort claims limit in the insurance clause. That protects the state up to the tort claims limit. Can you reduce them because it's a $5,000 software license that you're buying? I don't know. Maybe the $5,000 software license has FTI going back and forth, federal tax information to this vendor. I wouldn't suggest if you're sharing federal tax information on this $5,000 software license. So those are risk assessments that you're going to make in your agency. Again, document it. Document these things. I see a lot of great agencies that are doing it. They're loading emails from their general counsel or their legal team into supplemental documents that says, these are the reasons why we did it. These were acceptable. And that's very helpful. And it's of course going to speed your clearances or your review by IDOA. Also, pre-review. Yes, I am happy to look at your contract, as I'm sure the other approving agencies are, but at least please 2 weeks. I know there's sometimes a lot of speed is necessary, and I'm happy to try to update that. But if you're in the beginning of your negotiations and you'd like me to take a look at it, offer some suggestions, I'm happy to do that. But just give me about 2 weeks. If I can get to it sooner, super. If not, I'm happy to offer my comments within that time period. And of course, my little heart fell down when it got changed to a PDF, but we love form approved contracts. If you've modified indemnification, you've added a limitation of liability, you've added all kinds of information, and it's been form approved by the Attorney General's office, makes my review much easier. So we do encourage form approval. So I want to talk just briefly about the addendum. The addendum is a tool for us to use to protect the state when we are entering into agreements with vendors who like their own contract better than ours. So of course, I'm sure the AG, I don't want to steal their thunder, never sign a vendor's form contract. It was beat into my head for 5 years, never sign a vendor's form contract. There could be stuff in there that says Kentucky law applies. We can't agree to that. So that's the first thing. The addendum is a helpful tool, but it isn't a pass on filling in your duties. So this I see a lot, and it passes muster. I approve it and I move it on. But what happens is when I look at this, I have to read the form contract in 8-point font amongst my 10,000 other documents that I'm looking at to find out what it was that your agency is purchasing from this vendor who has a 25-page document attached at the back in 8-point font. So please help me out and put in what you're purchasing. I don't have a lot of time. I did bring an example of an agency just sent something through. It was great. But of course, the consideration also needs to be clearly defined in the addendum. It is a little shortcut. You know, here we go, $885,000 for, you know, this contract. Are we paying them by the hour? Are they getting $750 an hour? Are there 50 licenses at $10,000 a license? This is from an actual contract. It's not helpful for me in my review. And when I go to the form contract, I have to dig through it to find out what's going on. And I'm sure everyone here loves to get my email that says, what are you buying? How many of them? Why? Why isn't it aligning with your procurement? So here are some of the other things we do. Of course, real estate transactions. Steve Harless is the deputy commissioner there, and Robert Grossman is Public Works. I work with them on their contracts as well at IDOA. And we could go on to a whole new session on some of those topics. These are where their templates are. If you need those, I've been updating those as quickly as I can. Before I finish, I want to just say a quick thing about fleet services. I'm working with John Purdy for the past couple weeks on updating our fleet policy. And it has come to my attention that people who drive state cars think that the state is self-insured. And they say that I have a self-insured document in the car. So I asked Nancy Morris, who is the director of fleet services, to send that to me. And indeed, that document does not say the state is self-insured. This car is not self-insured. It says, if you have a claim against the state, you have to file a tort claim. We do not carry insurance. And the law, and perhaps the AG will address it, says we cannot purchase insurance in some instances. So I've updated some of the documentation and we'll be pushing that out to everybody who drives a state car. And I definitely want to thank everyone on behalf of my commissioner and Aaron Kellum and all of our team at IDOA. This, the 2 years when we were home and we all went back and we pushed out all these contracts and millions and billions, I guess, dollars worth of grants. We did it all. We did it all with your help, and I'm very grateful. And I look forward to continuing to work with you. Thank you. The Attorney General's office is next. We have William Anthony, also known as Bill, that's his AKA, and Philip Gordon. They're going to talk about Contracting 101 from the AG's perspective. Thank you. Sorry, forgot my duty.
Good morning. So my name is Bill Anthony. Seated to my right is Philip Gordon. We're with the Office of the Attorney General. We work in the advisory division. And I thought I was going to trip up those steps coming up, so I'm doing good so far. No, we've taken a brief hiatus from this presentation, but it's really good to be back and nice to be here to provide information about the state contracting process to everyone. See a lot of familiar faces in the audience. There are also several new ones. So whether you are brand new to state contracting or have been doing it for years, we're hopeful that you will gain some insight into the state contracting process that you can take back to your day-to-day jobs. So let me first start off by acknowledging that when I was in my first year of law school, sitting through my first year contracts class, I never really dreamed that I would be here presenting on contracts, but here we are. So without further ado. So you heard what IDOA reviews for, and we're going to provide some very basic information to you before we drill down into some of the finer details. As the beginning point, the Office of the Attorney General reviews for form and legality as provided by Indiana Code Section 4-13-2-14.3. We have 45 days by statute to review. And if we don't respond within that 45 days, the contract's automatically deemed approved. The Office of the Attorney General is always the last reviewer in the process. We're reviewing the final document to which all of the parties have agreed. And there's 4-13-2-14.3. Few points just to highlight. First, you have to use the correct form when you're contracting. That's there. Second, the contract must meet all requirements of law, which we'll discuss in further detail in a moment. And finally, the deputies that review and approve your contracts have all been delegated the authority to do so by the Attorney General. That information in mind, we'll start looking at some of the more nuanced information. So with apologies to contracts professors out there, what is a contract? Black's Law Dictionary defines it as an agreement between two or more parties creating obligations that are enforceable or otherwise recognizable law. Why is a good contract so important? Or stated another way, why are we here today? I've included a long paragraph from Ryan V. Lawyers Title Insurance Corporation, which you're free to read, but to summarize what it says, we do not want an ambiguous contract that's subject to interpretation beyond the four corners of the contract. We want determinations based on the words on the page. This is where you come in on the process as you negotiate your contracts with different vendors. So 6 goals to keep in mind when you're drafting and negotiating your contracts. First, use clear, unambiguous terms or phrases. State what you mean. Second, be concise. Don't get too wordy, as lawyers sometimes like to do, myself included. Brevity is always key in good contracting and drafting good clauses. Third, and perhaps most importantly, don't agree to prohibited terms. Fourth, that goes with number 3, include all necessary boilerplate terms, which we'll cover here momentarily. Fifth, perform a proper risk assessment when negotiating terms. I know IDOA mentioned risk assessment in their presentation as well, but want to pause here to kind of explain what I mean without getting way too deep into the weeds. A risk assessment is reviewing the probability and consequence of the risk you're taking on and the possibility of some clause or term harming the state. That's at the very high level. The Office of the Attorney General, we're hoping to have something, a document, a guidance document of sorts, in more detail on that here in the near future to help your agencies perform proper risk assessments when you're negotiating your terms. And yeah, so stay tuned in that regard. Final goal, and this is your fail-safe. When you have any semblance of doubt about the legality of a term or what it means, contact either the Department of Administration or the Attorney General, preferably both. We're always prepared to review contracts and their terms and provide advice and guidance to our client agencies. So what happens when a contract gets routed to the Office of the Attorney General? gets routed to the advisory division, as we're the division within the office responsible for all matters contracts related. Jean Marie, who manages our contracts process and all SCM contracts, receives the contracts first. She then assigns them to one of 11 deputies who review contracts on behalf of the Attorney General. We strive to have our contract reviews done within 10 business days. I think we're averaging well less than that now. So helping move the contracts through the process. The advisory chief counsel is delegated sole authority to approve contracts in excess of $10 million. Certain DAGs in our division have delegations up to 10 million, but most of our DAGs have delegations up to $3 million. Among other things, contract reviewers will make sure that referenced exhibits are attached, term and consideration amounts are consistent, and in the case of an amendment to an existing agreement, that the underlying contract is not expired prior to execution of the amendment. In the course of our form and legality review, the OAG reviews for basic information, which I've listed here for everyone. Term, does it line up? What I mean by that as an example, when you say a contract's for 2 months, are the dates listed 2 months apart? Consideration, did you state it correctly and consistently throughout the document? Are the parties correctly referenced in the document? Is the document signed and do the signatures line up? Are the exhibits clearly that were included, are they correctly labeled and referenced or incorporated? Are they all attached to the agreement, the ones that are referenced within the agreement? Are all the state boilerplate clauses included, the mandatory ones? And are all prohibited clauses excluded? So there's a lot of mandatory clauses, a lot of prohibited clauses that we can't agree to. We're going to go into a little bit more detail since this is a Contracts 101. I'm going to turn it over to Philip Gordon to discuss that with you in more detail.
Hello, everyone. Good morning. Bill mentioned my name is Philip Gordon. I'm a section chief in the advisory section of the Attorney General's office. I have been with the section for about 3.5 years. Before that, I was in litigation. I spent some time in private practice and also some time in the higher education industry, which is really where I got kind of my Contracts 101 with state contracting, working with education grants and other affiliation agreements on a college campus. So as Bill mentioned, I'm going to talk a little bit about the required clauses in contracts to start out with. Then we'll shift to some of the prohibited ones. I've only got a couple slides here to go through. I'm going to talk generally a little bit about each bullet point, try to move pretty fast because we've only got a few minutes here. So the first bullet point there talks about compliance with laws. And this is a provision that's it's pretty detailed. It's a straightforward provision that's in all contracts. It contains some of the same provisions we're going to discuss there below, ethics, telephone privacy. But its purpose is to essentially assure that a contractor and his agents understand their legal obligations when it comes to working with state entities. The ethics portion of this is the part of compliance that talks about compliance with laws. It talks about what's prohibited from a state employee standpoint and having a financial interest in a contract and certain disclosure requirements that apply to that. Telephone privacy. This is a provision that protects Indiana consumers, flat out. It essentially operates as a certification and an affirmation that a contractor is in compliance with Indiana's telephone solicitation laws. So it also provides for the Attorney General's office to bring a lawsuit in the event that a contractor, if they're in non-compliance with these telephone privacy laws. Electronic payments. This can be found in statute. Essentially provides that a person who has a contract with the state or submits to the state, invoices to the state for payment shall authorize in writing the direct deposit or electronic funds transfer of all payments by the state to the person. So it's really wordy, but basically what that's saying is that if you have a contract with the state, you need to authorize electronic payments. Verify provision, another required provision here, really requires that the public contract contains a provision requiring that the contractor enroll in and verify the work eligibility status of all newly hired employees of a contractor, and it works through the E-Verify program. Drug-free workplace. This is an executive order. It dates back to 1990. It was signed by then Governor Evan Bayh. And it's pretty substantial. It sets out some various requirements. The gist of them are really for contractors to make a good faith effort to maintain a drug-free workplace. If the total amount of the contract is in excess of $25,000, then there's other requirements that kick in as well. So this is one that I know we've gotten questions about. We've gotten pushback. I know vendors have pushed back on this on occasion, arguing that they cannot comply with every section of this executive order. I think partly maybe it's because it's dated a little bit. Otherwise, it's just because some vendors, they don't have these types of programs in place. So if you do get these kind of questions, we've worked with state agencies to kind of resolve these in the past. Feel free to reach out to Bill and I, any of our attorneys in our advisory section. We're happy to help out there. Governing law. This again is pretty straightforward. As state entities, we don't want to subject ourselves to any other state law. We want Indiana law. We don't want to waive any of our immunities that are otherwise going to be in place for us as the state. And more simply put, it just provides that Indiana agency contracts will always be governed in Indiana courts by Indiana law. Funding cancellation. This is discussing cancellation when funds are not appropriate, essentially. Determination is made by the state budget agency, and their determination is final on this. Non-discrimination. Generally, this is not a provision that's a point of contention. It is a pretty boilerplate provision. It's a statutory requirement that every contract to which the state or any of its political subdivisions as a party are required to abide by. And then finally, non-collusion. This again is a standard attestation clause. You'll see it at the end of every agreement, essentially binding the contractor to the contract. Clauses, again, I got like 5 minutes. I'm gonna try to go real quick here. Starting out, any provision requiring the state of Indiana to provide insurance prohibited. So the standard and state insurance provision can be modified, but it should not be modified for the state itself to be the one providing insurance. The state cannot purchase liability insurance, as Tammy had mentioned. The state's self-insured, but we pay out our own claims. We cannot provide or obtain additional insurance. Indemnification, requiring the state to provide indemnity. So what does it mean to provide indemnity? Well, indemnification is the contractual obligation of one party to compensate the loss of the other. So we commonly see contractors seeking to modify this provision, either to make it unilateral and one-sided to them or to make it mutual. You can't do either. Can't modify it. Touched upon this already. I read the construed in accordance with laws other than those of Indiana. We just don't want to do it. We can't do it. Expose the state to greater liability risk by doing something like that. Any provision that the suit can be brought in another state than Indiana, same here. That's pretty straightforward. Don't want to waive any of our state immunities by possibly agreeing to that in contract. Another provision that's prohibited is providing for resolution of contract disputes. State entities cannot agree to binding arbitration. In particular, releases of settlement agreements involves a release of a legal claim. And legal claims have to be processed in accordance to Indiana code, and that requires the approval of the governor's office and the Indiana Attorney General's office. A little bit here. Resolution of contract disputes, informal dispute resolution process. Tammy's going to talk about, I think, maybe a little bit about that later with IDOA and how they have a dispute resolution process in place when it comes to contracts. Skip to slide 3 because I'm running out of time. Okay. Any provision modifying the applicable Indiana statute of limitations. So quite frankly, the statute of limitations is there. It's set in place by the legislature. You can't modify it in contract. You can't change it. Same with relating to the time with which a claim must be made. This cannot be modified. Any provision requiring payment of consideration in advance unless authorized by an exception listed in Indiana code is prohibited. That one's pretty straightforward as well. Now, real quickly on public access, we've heard a little bit about public access already to contracts. You can't have a provision that limits the availability of a state contract. State contracts are public documents. They're posted on the state transparency portal. And similarly, if an outside entity, an outside person is asking for a copy of that contract directly to you as the holder of that within your agency, generally it's going to need to be disclosed. Any provision requiring payment less than 35 days, also prohibited. Providing for automatic renewal. Instead of doing or executing automatic renewals are prohibited. Instead of doing an automatic renewal, the thing you should be doing is executing an amendment. This is generally going to be the best thing for you. We don't want contracts renewed in perpetuity. It's bad policy. It's going to be a bad business decision generally for you to continue to renew without going back and actually examining the terms of that contract. So these are kind of a few of the points I want to touch on, and I think switch it back to Bill here. He's going to talk briefly about form approvals and the Attorney General's role in pre-reviewing form approvals for agencies.
Thanks, Philip. I've got 1 minute and 5 seconds.
That's right.
So, form approved contracts. We want to touch upon that. It's a service that the OAG offers to help you efficiently manage your contracts. A form approval is a template form, which is valid for 1 year from the date of approval. It's intended to be used when an agency anticipates a high volume of contracts or grants for the same purpose with different contractors or grantees. There's a difference. Don't confuse form approvals with pre-review approvals. A form approval is an actual form template used by the agency, whereas a pre-review approval typically involves a unique situation where the agency wants to ensure that once a contract is signed by the agency and vendor, it will not be rejected by the Attorney General on the legality issue. The distinct advantage to a form approval is the contracts or grants that you enter into using the approved form do not have to be reviewed by the OAG for form and legality. In essence, you get to skip a step. An important development reminder regarding form approvals: no changes can be made to the approved form once the OAG approves it. Here are your steps to get form approval. There's a form you submit. There's the email address. Make sure you submit your draft contract grant you're submitting in Microsoft Word format. Include a prepared by statement, and make sure that any exhibits or attachments referenced in the form are included and labeled properly, or at a minimum, just put placeholders. Once the form is approved, you'll receive form approval letter via email. IDOA also receives a copy of the approved form in email. Reminders when using these templates: it's your responsibility to request a form approved template get created in SCM. Make sure to destroy any previously approved forms along the same lines of forms that were previously approved. And form approvals expire exactly 1 year from the date of the approval letter, and continuing to use an expired form will prevent full contract approval. If you amend an agreement that has previously been form approved with a standard amendment, you will need to manually select the correct approval path in SCM. Since the amendment will follow the previous form approval path, which will bypass our approval, and your amendment won't be valid without our approval. You could also use a form approvement amendment as well. So with that, I covered everything. Refer to the slides if you have questions. I went a minute over. Thank you.
Thanks, Bill. We'll let you off the hook for that minute. So, thanks to everybody presented in this first session. I think you got a lot of great information, a ton of information. That's how it's going to be. We're going to take a 15-minute break. So we're going to just go ahead and make it 9:45 to come back and start again. Just try to keep us on time because I know we all have busy schedules. And we're going to hear from State Budget Agency and IoT. So 15-minute breaks. All right. going to go ahead and get rolling. So the second session is going to be great. We have state budget agency and IoT with some things that you may not think about so much in the contracting process. I did want to harken back one thing about when we were going through what can be and can't be in a contract and what are the prohibited terms and what the state can and cannot do. If you're new to contracting or negotiating contracts with vendors, or more importantly, if your vendors are new, do yourself a favor very early on in that process. Talk to them about this stuff out of the gate, because I will tell you, when things get messed up on the back end trying to get approval, it's because that hasn't happened. So just one more thing to think about. Make sure you're starting to bring those things up so people know that, particularly if they're not experienced with contracting with the state. So next session, we're going to have John Van Arks and Jim Eisenberg and Terry Messer. They are from State Budget Agency and IoT with some great information for you. So, Chuck?
Thank you, John. Appreciate the introduction. And also thank you to your team for setting up this seminar. Thank you also to Tammy and your folks at IDOA. I know it's been a couple of years since we've been together, and it's certainly great to be a part of the seminar again. Again, my name is John Von Arx. I'm a senior budget analyst with the Indiana State Budget Agency. And a couple things I wanted to discuss before we get started. Wanted to give just a brief summary of our agency. Also wanted to cover a couple things related to the approval process that we see on our end, and also wanted to touch on the newly updated financial management circulars. These were, the old ones were repealed and updated on December 31st. The new ones went into effect in January 1 of 2022. And while I have everyone here, we actually have our agency is hosting kind of our own town hall summit tomorrow, I believe in this room from 1 to 4. So if you're interested in being away from your desk for another half day, please feel free to sign up for that. And just quickly, if there's really two things you take away from my presentation, I only have 10 minutes. It's the funding cancellation clause, which has already been discussed, and also that agreements between state agencies have to be done via MOU. So I'll go ahead and get started. Our agency was founded in 1947 during the Financial Reorganization Act, which actually created the Division of Budget, and that has since kind of morphed into the Indiana State Budget Agency. And if this is if you're new to state government, or this is your new seminar, we're structured kind of as you see on the screen. We have two deputy budget directors. We have one state budget director, that's Zach Jackson. It's appointed by the governor, and we serve as the fiscal analyst and policy advisor to the governor's office and really executive branch agencies here throughout the state. We're also, we also are involved every 2 years in the budget development and implementation process. And again, if you're new this year, it's your lucky day, because we're actually beginning that process now to kind of create and craft the FY24 and FY25 budget. So that's a little bit about kind of the history of our organization. If you'd like more information, you can find it in Indiana Code Title 4, Article 12, Chapter 1. Along those lines, our office is able to, as I mentioned, create and enforce financial management guidance or guidelines. We call these FMCs. And the previous ones were repealed last year. We issued some new ones January 1 of 22. And I know I've heard from a few folks that maybe they weren't aware that these were sent out, and certainly we're happy to address those issues at our own seminar. But I also wanted to provide the location where a lot of this information can be found, so you can refer back to that. And I think we're going to post these slides to IDOA's website. Quickly, the contract creation process. I believe I I did not create this myself. I think I pulled it from the contract manual. But kind of where does SBA, where does our agency fit into this, into the process? And I will say really in a couple locations, we do approve requisitions over a certain dollar amount, $75,000. And we're also kind of slotted in between steps 6 and 7 when, again, the contract goes out for electronic signature via the supplier contract management system. And visually, how does this look? And again, I'm not going to spend a whole lot of time on this, but it hopefully is reviewed and signed off by the agency approver. From there, it goes to IDOA, IoT, if there's an IT scope within the contract or agreement. And from there, it then routes to our office. And again, kind of based on the makeup and of how our agency is structured and the dollar amount of the agreement, the total consideration, it will either go to a budget analyst like myself. It could also go to a assistant director, a deputy budget director, and potentially the Indiana State budget director if it meets certain thresholds. If everything is included in the agreement, the funding cancellation clause, other things we look for, it then routes to the Attorney General's office for final approval. I'm going quickly here. So, and so what are some other fiscal impacts or issues we look for? You know, what's the total cost of the contract? Again, this has been discussed. Year-over-year impact. We obviously want to make sure that the CFO or agency approver has signed off on the agreement. Cost per unit, cost per hour. I think Tammy touched on some of these issues. If you have any questions, we're happy to work with your agency to make sure that this information is included. Again, funding cancellation, one of the things I wanted to leave you with, I think we're all probably aware that this clause needs to be included in every agreement that is sent out for signature. I won't read it word for word, but it basically says that if funding is not available, the state budget director has the ability to cancel the contract, and that determination is final and conclusive. Other key clauses we look at: termination for convenience. While not mandatory, this is highly recommended. I'd say 95% of the agreements I see include this clause. Sometimes MOUs do not have termination for convenience, but certainly we would recommend that you include this in any agreement you send out as much as possible. We also look at out clauses with leases. We look at performance measures, outcomes, service levels, consideration and term. I know Tammy touched on this as well, but we want to make sure that those are included and fit within the current budget period that we're in as well. Quickly wanted to touch on the contract review process. Again, I wanted to make sure that we all understand kind of how that approval threshold works. And if it's above a certain amount, our office will, and frankly, I think PeopleSoft will loop in other signatories. And I will say that if there's something you need done quickly, please reach out to our office ahead of time, especially during legislative session. We tend to get pretty busy over at the State House, and sometimes things can fall through the cracks. So if there's something you need turned around quickly, please let us know. But I will say we have an internal goal to get things turned around within 48 hours of receipt. At minimum, at maximum, those contracts are usually done within 5 business days. And lastly, coming up here on 10 minutes, the MOU process of agreements between state agencies. This is, again, a requirement in our office. Any agreement, whether there's a dollar amount or a consideration involved or not, needs to be done via MOU. I won't get into the accounting side of it, but we do recommend that those are should only extend as far as the current budget period. So for example, that would be July 1, 21 through 6/30 of 23. I would say that we need to see any agreement again between state agencies. We need to see this as backup documentation before any funding can be transferred or any expenses can be journaled or sent to the receiving agency. So I think I hit it almost right on the market at 10 minutes, John. I know we're going to have some Q&A later this morning, so maybe we'll leave a little extra time for that. But thank you again, and I'll turn it over to the Attorney General. Thank you.
John brought up a good point that I just want to touch on with MOUs. MOUs in state parlance, if you will, has a very, very specific meaning. So make sure you're only using them for the purpose of which state agencies use them for. So how does the state manage upwards of 10,000 contracts per year? In partnership with IDOA, we have carefully designed several templates for the use of our state agencies. These templates have evolved over time, and clauses have been drafted to ensure that legal requirements are met and that the state's interests are protected as best they can be in a contractual relationship. Simply put, without the use of templates, the reviewing agencies, IDOA, SBA, OAG, cannot do their jobs efficiently or effectively, which means you all can't do your jobs either. Updated templates are automatically uploaded into SCM. As a reminder, make sure you are using the most current template when you're uploading your document into SCM. All of our standard templates are available for viewing at the IDOA contract management website, which I've linked there. Agencies may consider customizing a template for use, but please coordinate with IDOA and the OAG prior to doing so. This will ensure your contracts route through the approval process in the most efficient way possible. So now I just want to turn our attention to a few of the more specific templates that we get questions on more often than others. First is the addendum template. The addendum template is used in those situations where a vendor is insistent on using their form contract in the course of an agreement. As a reminder, and as said before, I think IDOA, never sign the vendor's contract. Instead, use a state's addendum form. A vendor's form contract oftentimes does not account for the state's best interests and may contain clauses that are illegal in state contracts, such as conflicting governing law, indemnity, agreement to arbitrate, etc. Always remember, regardless of what the vendor's account executive is telling you, the vendor's boilerplate terms are always negotiable. A few development reminders about the addendum. The addendum must always take precedence over the form contract. See the first paragraph of the template, which states as much. The addendum contains a laundry list of terms and conditions that the state cannot agree to, which Philip covered in the first part, and the vendor must agree that these, if any, are deleted from their form contract. The addendum also contains terms and conditions which are required by law to be included in state contracts when a state agency is a party and public funds are being spent. As you're drafting an addendum, please make sure you take the time to read the vendor's form contract. Don't just simply attach it, as it may contain terms that are important for your agency to be aware of and to account for in the addendum. For the most part, though, our addendum is drafted in such a fashion so that the agreement meets minimal state requirements. To process an addendum through SCM, make sure that the vendor's form contract is attached to the addendum. Amendments. Anytime your agency is modifying a contract, update dollar amounts, extending or changing the term, revising the scope of work, or changing the name of the vendor, execute an amendment and route it through the approval process. As an important development reminder in this regard, an expired contract cannot be amended. So a contract is deemed to have expired if the amendment is not signed by the vendor on or before the expiration date. Your contract does expire, can't use an amendment, you'll have to enter into a new contract. Outside counsel template. Per Indiana Code 4-6-5-3, agencies must first obtain OAG consent prior to entering into an agreement for legal services with a law firm or attorney with limited exception. The statute that I cite there, it provides the requisite statutory authority to the OAG for consent to hire outside counsel. An approved request to hire outside counsel will actually receive a consent letter from the OAG. The consent letter must be attached as an exhibit to your outside counsel agreement. Any type of amendment to an outside counsel agreement also requires prior approval of the OAG. Requests for amendment must be submitted in the same fashion as the underlying request, and a new consent letter will be issued for each amendment. A contract amendment must be executed following consent of the OAG and should include, or not should, must include the updated consent letter as an exhibit to the amendment. So I want to turn now from templates and talk about some of the common errors that we see in the course of our review. I'm going to have Philip come back in a moment to discuss these in more detail with you, but I did want to at least introduce the issues beforehand. Consideration errors, it's a big one. We frequently see this when agencies try to spell out the consideration amount rather than just listing the dollar amount. Keep it simple. We see consideration errors in the form of numbers not adding up or the total remuneration amount not staying consistent throughout the document. We see documents where pages are missing. That's another big one, or out of order. Term errors is another area. We see those errors pretty frequently. A term length, you state a term length like we talked about in the first part, and then the dates listed don't match that length, thereby creating ambiguity, inhibiting our approval. Attachment and exhibit errors. Some examples include attachments included that are not referenced in the document, as well as attachments referenced in the contract and not attached at all. Both of those things would prohibit or inhibit our ability to approve your contracts. Some we've seen recently, calling something Exhibit A and then attaching it as Attachment A. Stay consistent in your naming of your amendments and of your attachments and exhibits. Missing or altered boilerplate clauses, especially see that in some ones that Philip will be talking about, drug-free. Some of the language gets impermissibly altered that just frankly, we can't approve. And finally, improper business decisions when you're negotiating a contract. Again, that all goes back to the risk analysis that we touched upon briefly. So that introduction in mind, I'm going to let Philip come up and touch upon these in a little more detail with you.
Thanks, Bill. We've had some time since the last contract seminar, I think, like roughly 3 years or so. So we've been able to compile, quite a bit of a comprehensive list of some of these issues that have been popping up, at least in our review process. Some of these are repeat offenders. They happen almost, well, not daily necessarily, but certainly weekly. Some of them are a bit new, so it'll take some time just to highlight a few of them for you. Consideration errors. This is one, Bill talked about. This is one that's popped up quite frequently. So what is consideration? I guess, quite simply, consideration is just a legal term in contracts for what is bargained for. It's ultimately what's being exchanged between the parties. It's a fancy word you'll see in contracts. Sometimes vendors might see that and we just ask, well, what does that mean? Especially if they're not used to seeing that in their contracts. Common types of consideration can include property, service, return promise, some other act. More commonly, as you see in our agreements, it's typically a dollar amount. Always check the consideration amounts and the total remuneration, which remuneration is essentially the total numbers during the course and term of that contract. As I tell my 10-year-old daughter often, math is hard, but if you slow down and take your time, you can figure it out. So I would put the same mantra toward contracts, just calculate the math, slow down, take your time, don't rush. If there's amendments, go back and look at those amendments, see what those numbers look like. When inputting dollar amounts, don't spell them out, use only numbers to show consideration. That's always very helpful. Real quick before I move on, I was going to mention too that our advisory DAGs, when they review contracts, they're not click and approve, deny. There is a middle ground on these things. And if they see a consideration error, if they see another error that we're going to talk about later, generally they're going to be reaching out to you. They're going to communicate that error to you, give you a chance to withdraw it, correct it. We don't like denying contracts. We'd much rather have you withdraw it and resubmit it. Missing pages or documents. This is pretty straightforward. These are omissions. They simply just require a little more attention to detail. If we're missing, pages 3 and 4, we're not going to be able to prove it. I mean, it's just not going to happen. So assure the page numbers are included and that they're in the proper order. These contracts, once they're approved, they're posted, they're out there for everybody to see on the transparency portal. So we want them to be, 100% correct, and even as something as small as a page number error. Term errors. So this is another common one. It creates confusion when the dates and the length of term of the contracts are misconstrued. It happens when there's a failure to reconcile the actual stated length of the term to the corresponding start and end dates. So always make sure that the term of the agreement aligns with what is actually stated. Put an example up there just to kind of show you how this happens in practice. We'll have a date range that shows up in the contract, but then the person may say it's for a year. Well, the date range doesn't align to a year. So from a form legality standpoint, we can't prove that because it creates clear ambiguity within the contract itself and will prevent our approval from going forward. Failure to incorporate exhibits. This might be one of the bigger ones that we have seen, especially over the past year. This again is one we see on a weekly basis at times. I mentioned it here to emphasize that exhibits must be properly labeled. They must be properly incorporated and referenced within the contract itself. Simply attaching a document is neither necessary nor sufficient for incorporation. Indiana case law is pretty clear on this point. There's a number of cases out there talking about proper incorporation of exhibits. So why is this so important? As we've touched upon, so that it's clear to individuals looking through the contract and a series of amendments, especially when you get toward amendment 9, 10, 11, that the exhibits to those amendments and that an exhibit hasn't been left out or improperly referenced throughout the term of the agreement. This includes situations where there's an amendment attached but not incorporated in the language of the contract, or situations where an exhibit is incorporated in the contract and then not attached as part of the final submission. So if an exhibit's not properly incorporated, we'll go ahead, we'll have to ask you to withdraw it and be resubmitted. Required clauses that are missing or altered, as mentioned from the previous slides, this is state required contract provisions or the state contract required provisions should not be altered or omitted. Vendors should understand this at the beginning of their negotiation. These are non-negotiable. They're required to be inserted into every contract under Indiana law. And it shouldn't come as a surprise to state entities that are required by law to have these in the provisions of their contracts when you negotiate with vendors. So this should be expressed to them upfront. Lastly, this is another big one, which we've touched upon. Bill mentioned briefly that the Attorney General's office has in the works, where we're working on getting some advice to state agencies on this issue of a risk analysis. And really, again, it's something that's been popping up more and more. Again, as an example, to use my 10-year-old daughter, just because you can do backflips on concrete doesn't mean you probably should be doing backflips on concrete. You probably should be doing an assessment of whether you should do that first or not. So understanding the risks associated before you actually execute something generally is always going to be a good idea. There certainly are consequences that follow if you don't do a proper risk assessment. It's more frequent where agencies may be making decisions to remove these contract provisions, at least as we're kind of seeing on our end, where it's more of an arbitrary decision rather than just looking at the big picture and how this is really going to affect your agency. It's the old mantra, just like the backflip situation, just because you can doesn't mean that you should. Agencies should be cognizant that while a contract may be approvable, it doesn't mean that the state is protected against unnecessary risk. We mentioned again, and I think it's up there on the slides, talking about higher dollar amounts. It's always going to be an issue with higher dollar amounts where an agency has maybe agreed to remove all insurance requirements. It's generally not going to be a good idea, no matter what the situation. And then in bold font there below, additionally, limitation of liability clauses are another popular one to state contracts. You should remember that the state cannot accept liability of another, and you should review and understand in what ways the contractor is limiting its liability and be mindful of the type of service and again, the dollar amount of those contracts as well. So that's basically what I wanted to touch upon as far as the main points that we've been seeing here, especially over the past, again, we've had a lot of time to compile these. There are more, I'm sure there'll be more next year that we can talk about as well. But with that, I'm going to turn it back over to Bill. Bill's going to talk briefly about another provision that we've been seeing, force majeure provisions. He'll tell you what that means and give you a little bit more insight about that.
Thanks, Philip. One other thing, I'll piggyback on what you were talking about. A big thing, and I think IDOA Tammy had touched upon it in her presentation as well. Make sure you're spelling out the duties of your contractor in detail. So we understand and both parties understand what they're getting is their benefit of the bargain. Force majeure. What is a force majeure clause? A force majeure clause is one that aims to excuse one party's performance when such performance is prevented by circumstances outside of the party's control. What ultimately controls should a force majeure situation come up is whether there is specific language in the contract that excuses performance because of a specific type of event. So this has come up with a little more frequency of late with, we've been seeing some force majeure clause altered. For the lawyers in the audience, you can review the specialty foods case, which I've cited on this slide as an example as to how a court has reviewed specific language in a contract to determine whether a force majeure event actually excuses a party's performance. The state has we have a boilerplate clause in our contracts. It's written pretty specifically. Would highly recommend not altering it. For state contracting purposes, a force majeure event is one that is by an act of God or caused by a natural disaster. What's that mean? Guess I'll provide a Hollywood example. If Bruce Willis and Ben Affleck had not destroyed that asteroid heading for Earth, that likely would have been a force majeure event. So, yeah. So all that to say, just be mindful of this clause, as it's very important. Never agree to a force majeure clause that's tied to economic considerations or economic performance or something that is beyond the state's boilerplate provision. So I think if you do that, you'd be in pretty good shape in terms of force majeure. So I've got about 8 minutes left. And I've got the conclusion, which isn't 8 minutes. So to conclude and to summarize, I guess everything that Philip and I have said, IDOA said up to this point, SBA as well. The key to having a golden ticket in contract drafting is to follow the rules, rely on our form templates, and understand which provisions are required. Additionally, you want to be diligent in your review, and when in doubt, reach out with questions to either the OAG or IDOA. But with that, I think, if there's questions, anything like that, anything you want us to touch upon, we've got 5 minutes as part. Yes.
Acceptable.
So the question is, can the exhibits be incorporated into the recitals of the agreement? I think it would be acceptable. From a form and legality standpoint, I don't have an issue with that being the case. Yep. Good question. Yes. Acceptable, but I don't know that it would be, it makes it hard, right? Like I think best practice would be to reference all exhibits in the body of the contract itself and not via other exhibits. But I think we've seen it.
I think we have seen it. It would be difficult for us, say as the audit, I guess. we'd have. I think it would pass form legality. but having it spelled out more clearly in the contract.
Yeah, I agree with that. Good question. All right, we're 5 minutes early, but IoT has a lot of information, so they may need that extra time. So with that, I'm going to turn it over to Jim Ehrenberg and Terry Messer from IoT to cover their portion of the presentation. There you go.
So there are two parts to IoT's presentation this morning. I'm going to start us off with my take on how to include the substance that you need in your contracts. And first, I'm going to do that in two ways. I'm going to give you some basic advice that I think should be applicable to all of your contracts. And then on the back end, I'm going to try to give you some advice that I think is best for your IT contracts in particular. And then after I finish up with my tips for the substance of your contracts, Terry's going to, her presentation will be more about the process of getting them through the approval process, probably with an emphasis on IT contracts. So I always like to start off with a question kind of like this, because to me, as state employees, we sometimes get asked to do things that don't make sense on their face. And sometimes you have the option of not doing them, and sometimes you have to do it. And so from my perspective, it's always easier if I'm told to do something that makes sense to me. And the reason why I think it makes sense for you guys to listen to me and Terry on some of this stuff is because, next slide. Because really, in ways, we're an awful lot like your agencies. IoT has to have its contracts reviewed and approved by IDOA, SBA, and the Attorney General, just like all of you. But we also see it from their perspective as well, because we approve a certain subsection of contracts, IT contracts. And so what we're going to do with our presentations today is going to be kind of a blend of those two perspectives, where we see the IDOA, SBA, Attorney General perspective, but also your agency perspective too. When I first got to IoT, I've been here for 7 years now. I didn't really understand the logic behind having SBA or IDOA, SBA, and the Attorney General approve my contracts. I assumed it was basically a formality and that they would rubber stamp them. And once I got some pushback, I realized that the changes that I had proposed for our contracts, there was a reason why they were pushing back. And so I started to ask myself the question, what exactly is the basic purpose of the state's templates? And the answer is that these templates exist to protect us, right? IDOA's professional services agreement has 50 sections or so. And I'd be willing to bet that the majority of them are there because the state was burned in some form or fashion in the past. And really what the Attorney General and IDOA are trying to do is keep us from getting burned in the exact same way that we got burned before. That's important for you to keep in mind when you consider making changes to the template. You know, there's historical knowledge at, say, IDOA or the Attorney General, they see a lot more contracts than we do. And so they have this perspective where, look, you might not understand what you've changed and how it could affect you in the same way that I do, because I've seen the state get burned in this way before. So anyway, ask yourself if you're changing something that could keep, or that could allow you to be burned in the same way that somebody else has been burned in the past. This is another question. Next slide. So this is another question. Oh, I'm so sorry. I got ahead of myself. Okay, but anyway, thank you. What are the approving agencies really responsible for doing when they review our contracts? What do they want to see, you know? And the answer is they review to make sure that you have the minimum requirements that are necessary to keep us safe. I think there's a gray area like Bill and Philip were saying. At the end of the day, what might be right for you might not have been right for somebody else just because of the circumstances of your contract. But that's basically what we look for at IoT, is to make sure that you're doing the minimum that we can allow you to get away with and still bless your contract. That's the bar you meet for us, at least. And this is another question I considered. And basically, what are the approving agencies afraid of? What's their greatest fear? Why do they care what I put in my contract? And the approving agencies, you have to put themselves in their shoes. They don't know much, if anything, about what the product or service is that you're buying. They don't know why you're buying it, what project you're buying it for, or what your vendor is like, or what your vendor's terms and conditions are like. And so knowing just the very little that and really that's by necessity in a way, because again, they're seeing 10,000 contracts a year. And so at the end of the day, they can't dive into this stuff like we can at our agencies. We're responsible for doing that. You know, we have to make it easier for them in a way to feel comfortable with our contracts. They just know very little. What they know when they see changes, unless you do a good job of explaining why you're doing something, is that you're changing a standard protection in the state's template, probably removing it because your vendor has asked you to, and that makes them nervous. They don't want to see something go wrong with your contract. They don't want the state to have this contract explode in its face because standard protections that were there have been removed. So put yourselves in their shoes. I mean, that's what I tried to do 7 years ago when I first got to IoT. And I tried to envision how they must see IoT when we came to them and asked to remove certain standard protections from our contracts because our vendor thought it was the right way to do it. And I determined at that point that they basically saw IoT something like this. So for anybody that doesn't already know, this is Beaker from the Good Old Muppet Show. Beaker is hardworking and lovable, but he's also kind of a tragic figure because nothing ever goes right for him. And usually things go very, very wrong. You can tell Beaker works for IoT because he's got the Hawaiian shirt that's simultaneously cool and uncool. This is what the approving agency saw our prospective vendors as. At the end of the day, they don't know these folks because they're not doing business with them. And so this, of course, is Animal. Animal's also lovable, but go back one, would you? Animal's also lovable, but you can't trust him. He's crazy, right? And so he doesn't mean, in most cases, he doesn't mean to screw you over, but sometimes he does. And so that's what you have to think about when you ask to use your vendor's terms instead of the state's templates. All right, next slide. This is how I assume the approving agency saw me. That's IoT Legal talking with Beaker. And what we're doing here is removing standard terms and conditions from the state's templates that would have protected us. But our vendor said, you know, do we really need those? And so we tried to accommodate to get our deal done because our vendor wasn't being reasonable and we understood our boss is pushing for something. This is what we need. You know, so we do this. And this is how I envisioned the approving agency saw me. Next slide. This is IDOA reacting. Next slide. This is SBA. This is SBA discussing it with IDOA. This is the Attorney General. So this is, I assume, how the approving agency saw IoT using our new product for the first time. Everything looks good, be going good so far. This is how I assume they saw our product malfunctioning at some point down the road. And this is how I assume they envisioned IoT suffering harm that could have been avoided if we had included those standard terms and conditions, the protections that are there in in the normal course of business in our contract. This is a worst case scenario, of course. Most of us won't ever get electrocuted like Beaker, right? But you can't really blame IDUA, SBA, or the Attorney General for thinking that something catastrophic could go wrong. Because even if you change language in your force majeure paragraph, and it's fine for 99 out of 100 times, eventually you get to that 100th time. And so just keep that in mind. It's like, in ways, removing these standard terms and conditions is like riding a motorcycle without a helmet or doing backflips on concrete, right? You don't have to have the helmet to ride the motorcycle, but if you crash, it's going to be a whole lot better if you have that helmet. And so that's just basically my 2 cents on standard terms and conditions. Keep them if you can. All right. That ties in with this next slide here. At the end of the day, the approving agencies absolutely understand that your agencies need to buy things to do your work for the state. They want to help you guys get your contracts in place, and they often will do that. But their main job isn't to help you get your contract in place. It's really to help you by making sure that something doesn't really go wrong with your contract. That's the way I see it, at least. And so what my takeaway is, basic takeaway at the end of the day is to help the approving agencies feel comfortable with your contracts. Let them know why you're changing something and why it makes sense. This includes some of the risk analysis that Philip mentioned. At the end of the day, you need to instill confidence in them that you know what you're doing. That's the basic takeaway. If you take nothing else from my presentation, take that. And the easiest way, and this moves on into the next slide, the easiest way to do this again is to change as little as possible, because they then know, they're familiar, and I should be including IoT at this point too, because we are part of the approval process. We are familiar with our standard terms. We know what they do for the state. And once you guys start changing them, that's when we need to start to pay much closer attention to what's going on in the contracting process. We need to know what the deal is for, and how much you're paying for it, why you think changing terms is acceptable, all that stuff. So what I try to do is set the table for vendors from the very start. And what I do is I make a couple of basic points. I tell them, basically, to paraphrase this, the state processes thousands of contracts a year. We don't have a lot of staff to do it. It sounds like IDUA has 2 lawyers and 1 other person that helps out with the contract approval process. That's crazy. It's almost, I don't want to say anything because it could be held against me in court later on, but at the end of the day, you could make an argument for that being malpractice. You know, I mean, how can we get through 10,000 contracts? You can't do it unless you guys help. You really do have to help them help you, is the way I see it. And so the point you make to your vendors is if you change things, we've got to convince other agencies. And the other point to make, and this is kind of into the next slide, is at the end of the day, a lot of the approval process is out of your control as your agency. There are 4 other agencies that don't have a dog in the fight. You've got to convince them that it's appropriate, that you're not doing something that will get you burned like Beaker if you change something, you know, and your contract could get off the rails at any point in the process, because I think somebody said this morning, all of the approving agencies look at different things. You know, we have a different lens. And so what's going to be important to IoT might not be important to IDUA and vice versa. At the end of the day, it might get approved by IoT. I'll see something and I'll be like, doesn't matter to me, but I also know I'm probably going to get stopped in the process by IDUA. Anyway, so take a look at these. I've included extra detail. I don't have the time to get through all of this type of stuff, but I want you to have it and it'll be in the presentations. On to point 2. So the second point that I make to vendors from the start is this one. And any changes to our standard language in the templates will always slow the process down. You know, and sometimes it slows it down considerably because, again, we've got to pay closer attention to the terms of your contract. Then we know what will what our terms will do to help us. And if you start changing those things, then we have to, it sounds like a change should be easy to accept, but you have to understand how your vendor's terms will impact the state if that protection has been removed. This is extra detail. I'm not going to go through it in the interest of time. Point 3, this is the last point that I tried to set the table with before you even really get negotiating with your vendors. And I tell them, look, if we make changes, we need to help the approving agencies understand the thinking behind them so that they can feel comfortable approving them. And I tell them the less we change, the less we need to explain, and the faster the approval process will go. Extra detail. You can go. So everything that we've discussed to this point in my presentation really applies to all contracts, I think, not just the IT ones. What I'm going to do now is discuss specifically what IT contracts need to have in them when you submit them for approval to IoT. First, we'll discuss what parts of the state's templates IoT reviews, and then we'll discuss what you need to do if you want to make changes to those parts. All right, so this is what I call the IoT paragraph. It's technically the information technology enterprise architecture requirements. And what I want to do is touch on 4 points with regard to this paragraph. The first thing that I'll point out to you guys is that it starts off with if. And that means it only applies to IT contracts if you're buying technological things, products or services. It was purposefully written this way so that it would not need to be removed from our non-IT contracts. And sometimes people do ask to cut this out. What you're really doing then is adding an extra step. I don't disagree with the thinking, but what you're doing, and you should tell your vendors this, is you're adding an extra step. IoT has to look at this thing then and say, okay, you can do it. And it shouldn't take us a ton of time, but who knows who's on vacation or whatever else happens. And so at the end of the day, my recommendation to you would be to not change it, not remove it, just point out that if. The second thing that I'll point out is the language that's highlighted there, are compatible with. That's the standard that your vendors have to meet. We understand that they're not gonna, that their, whatever requirements they have, whatever standards they've set, they're not gonna say the same thing that IoTs do in the exact same way that IoTs say it. What this really means is that it has to work in the same way that philosophically that we envision our standard working. And if their standard meets that standard, then it'll pass. The third point that I'll say is, this is that last highlight down at the bottom. And basically, they only have to be worried about the standards that are applicable. At the end of the day, we absolutely know that not all of our standards are going to apply to every single product or service that you guys buy. But at the end of the day, we've tried to accommodate that by saying, look, you don't have to meet inapplicable standards, because why would we want you to meet them? But, you know, since we're lawyers, we have to spell it out, and we have to assure their lawyers that you don't have to meet those standards that are inapplicable, because we've said it right here in this paragraph. The last point that I'll make with regard to this, to the IoT paragraph, is that at the end of the day, I do not think it's unreasonable for your vendors to say which standards apply. But I will tell you that we cannot help you with that. We can't help your vendors. They're going to know their products and services much better than us. You know, I do feel like non-IT people, one of them, sometimes this gives IT people more credit than they deserve, in the same way that non-lawyers sometimes give lawyers more credit than they deserve, just because you don't understand what they're talking about. And so at the end of the day, technology guys can't look at your product and just know by looking at it that it meets all of our standards. So they can't tell you what you need to tell your vendor about which standards apply. We have to push that responsibility to the vendors. Thanks. So the IoT paragraph, the one that I just talked about, is one of 50 paragraphs in IDOA's professional services agreement. We may review more than one paragraph in those 50, but we don't approve them. And so at the end of the day, play a much bigger role in the cloud terms. Basically, what I want you to know is that the cloud terms are more or less a set of security terms that have been devised by our security team. They commonly get attached to cloud contracts as an exhibit, and that they are the default terms that are supposed to be used with all cloud contracts unless you get the IoT security team's permission not to use them. So changes are permitted, but you need to give the IoT security team enough information so that they can feel comfortable approving your changes. You can't just say, can we do this? Next slide. All right, and so this, I know many of you are probably uncomfortable with the idea of explaining why changes to the cloud terms are necessary. What I want to tell you is that it's not as hard as you think. The terms are pretty straightforward, and what you have to do is, again, think that they're there for security reasons and look at the section headings. They will tell you basically why they're there and what you need to be thinking about when you read those lines. Like data location is an example. It calls for data to be stored in the United States, and it says your vendors must store it in the United States and that they can't store it on personal storage devices. That's there for security reasons. What you need to do is explain why you can lessen those protections if you need to do it. And maybe the answer is, well, the data that we're storing with or we're giving to the vendor isn't confidential, or the other conditions apply. Something like that helps our security team understand what is what. Next slide. This is my last one, I think. And really, I'm not going to talk too much because I already hogged too much of Terry's time, but at the end of the day, this is what you need to tell the IoT security team. This is an important slide. It's basically describe what your deal is, why they should know about it, what you think you would want to know if you were in their shoes trying to determine what's going on in your contract. Second, identify the language in the cloud terms that you want to change. Third, explain why you want to change that language and what you want to change it to. And we prefer red lines in this stuff so that we can see it and evaluate it. And then fourth, what you ultimately end up doing is acknowledging responsibility, because we've set up certain standards to protect the state's data. If you don't want to meet those standards, that's fine, but you need to feel comfortable enough with the changes that you're proposing that you're willing to accept responsibility for something that would have been prevented if you hadn't made the change. Anyhow, I'll turn it over to Terry for the process part of the presentation. I'm sorry, it took a little bit more time than I thought it would. So.
So the great thing is I prepared myself for a lightning round. Here we go. Jim's laid out the path for success, the components that we're looking at in the approval process. We thought it might make sense to take a little moment to evaluate potholes that you can hit in that path because some agencies do very few tech contracts, right? Some agencies do a large number, but whichever pool you find yourself in, we'd like to make sure that we've done what we can up front to help you avoid delays, right? So one thing that we hear not infrequently is, why is my special procurement request being held up? I checked the 3 boxes at the bottom of the form. Did you read carefully? Because I know we're all trying to do as much as we can, as quickly as we can. And there's a good chance that the security questionnaire wasn't asked, requested from IoT or uploaded into your SPR when it went into the approval process. You can obtain that questionnaire in about a week from our new debuting here, contracts at iot.in.gov, so that we can be a little bit better aligned with IDOA and ATG in their contracts email nomenclature. But for the meanwhile, you've been getting us at IoT procurement. You can continue to do that. You're also welcome to email me directly. We hear periodically is, why is my contract being held up in the approval process, or why am I getting questioned about it now? Someone at IoT already took care of that for me. And we're very glad that you've already talked to IoT by the time your contract comes to us, I assure you. However, whether someone in operations may have approved a product you want to buy or a project that you want to do, whether you have gone to Archer to submit an exception request, or asked for any other kind of approval, like an SPR, the approvals that we do in the contract process are still specific to it. So everything that Jim laid out is necessary without regard to whatever someone else has already told you at IoT. This is in addition. Another perception that we run across occasionally is that when we receive a tech contract for review, we comb through every page and every word, and we look at each EULA in detail, that we're looking at the statements of work in great detail. And we are making sure that your agency has adopted the best legal and operational position. While I would love to say that we do that, or even that we can do that, we don't and we can't. And some of those are time constraints, but largely it's because you are the person who's closest to your deal. You and your vendor know what you're trying to achieve, and then you have a contracting person or staff, you have an IT head or staff, and you have a legal head or staff that are all going to speak into those decisions. So we trust that you've made those decisions before the contract comes to us, and then we're going to go from there. Maybe the most important one that we'll talk about today as we finish up. If I have a contract for cloud services and it's already been in place, gosh, it's been in place for 6 or 7 years. I don't have to add the cloud terms when I extend this contract. Or something similar that we hear is, I have a contract for some on-prem product and service, and it was approved by IoT. Now I'm going to migrate to the cloud. Since I have an existing contract, I don't need to worry about all those extra things when I do this migration. While I would love for those things to be true, because it would make life simpler, ultimately, it's not going to provide the protections that Jim spoke about. So if you have a contract in place, it may have gone in place before IoT's cloud terms even existed, or it may be that that you're doing a migration. Take the opportunity at the amendment stage, if you're extending or amending, to slide those cloud terms in there. It will speed your review and eventual approval. One point under steps for success as a lead. Email request to modify or delete the IoT paragraph as Jim described. Modify, waive, or replace the IoT cloud terms. Please, in about a week, should be sent to contractexceptions@iot.in.gov. In the meanwhile, again, please continue to use IoT procurement email or mine directly. Wrapping up, steps for successful IoT contract review and approval. Summary. I want to modify or delete the IoT paragraph. If so, have I engaged IoT? Does my contract include cloud services? If so, have I included the IoT cloud terms and the security questionnaire? If I want to modify the cloud terms, elect not to use them, or substitute a vendor's cloud terms, have I engaged IoT? So the theme, and thank you for our predecessor that shared it as a precursor. The best way we can help you is if we know at the beginning of your deal what you're trying to accomplish, so that we can support that. I didn't know that was going to be me. I suppose that's Jim and I over there, but I didn't color my hair for it or anything.
At the end of the day, it is a partnership, though. I mean, we do need your help to help you, so anyway, that's it.
All right, thanks to everybody in the second session. That was great information. And I know we'll all be using that very, quite a bit as we work through these processes. So we're getting ready to go into our last break, which will go into our last session, which will have an ethics and state contracting, which will be the ID's office. I'm very excited to see that. And then a small presentation on executive branch lobbying that's actually very important. I hope you are able to stay for that. But we're going to take a 15-minute break. We're running about 5 minutes behind, so we're going to extend that break 5 minutes to 10. Sorry. Let's be back here at 10:50. Oh, wait a minute. It is 10:50. Stay right where you are. 11:10. We'll start back at 11. Oh, I'm sorry. We got an hour break here. My bad. Full hour. We're just gonna have to go over a little bit. Yeah. Be back at 11:10. Thanks. All right. All right. I hope everyone had a nice break. We're going to get rolling again. Happy to have the Ethics and State Contracting presentation next. Sean and Doreen and Mark are going to present on that, and then we're going to have Tammy come back up from IDOA and talk about executive branch lobbying, and then we'll be finished for the day. Last note, if you didn't hear this, or if you need to hear it again, your certificate for CLEs, you can fill that out, leave it at the registration desk, or you can scan it, email it to us. If you're watching remotely, there will be an email as soon as the program is over for you to fill that out and email it back that way as well. So to make sure you get your credits. And remember, you have 30 days to get those in. So, Sean, take it away.
Howdy, everybody. Hi. Hello, welcome to the Ethics in State Contracting portion of today's seminar. We're going to change gears a little bit from talking about the nuts and bolts of the contracting process to more about the considerations from an ethical perspective when dealing with contracts or with vendors from your perspective as a state employee. So my name is Sean Gorman. Again, I'm the State Ethics Director working in the Office of Inspector General. And joining me today are Doreen Clark and Mark Mader, who are also from the Office of Inspector General. And we're gonna get this show on the road. So today we're gonna be reviewing, and we're gonna take a step back and look at the state's Code of Ethics. With a focus on those considerations involving state contracting, right? And as I'm sure you're aware, this presentation is going to entitle those attorneys out there with 1 hour of ethics CLE. Very nice, yes. There's the applause prompt. Okay, so that was shameless, I'm sorry. I'm gonna give you some information on the Office of Inspector General. A little bit of background and how you can use our resources to help you confront and avoid tricky ethical issues. We're going to touch on a couple of provisions of note from the rules of professional conduct. This will, again, be particularly relevant for those attorneys in here. And then we're going to zoom in and focus on a handful of the most applicable rules from the Code of Ethics. And then Tammy is going to tie it all together in regards to some post-employment restrictions by giving us some great information about executive branch lobbying. So the OIG, the Office of Inspector General, was created back in 2005 through executive order, then established subsequently by statute. Our Indiana Inspector General is Mr. David Cook. He was a governor appointee and leads our office and in its mission to reduce fraud, waste, and abuse and wrongdoing in state government operations. We have 4 major functions that I'm just going to highlight here. We have a code of ethics that we maintain. Prior to, now ethics have always been around, right? Prior to the implementation of an Office of Inspector General focused on supporting these activities, those codes of ethics were kind of scattered throughout the Indiana statutes, and we've consolidated them, updated them, and we maintain them. We also do things like we're doing today, reaching out and trying to talk to as many state employees as possible to make them aware that there is a code of ethics and what kinds of things they need to think about in terms of their ethical obligations and the restrictions that they might impose. So this is an ongoing effort, of course. The Office of Inspector General also will initiate, supervise, and coordinate investigations. Our office employs full-time special agents with full law enforcement authority to investigate complaints involving ethical code. That's okay. We'll let you finish that up. All right, and also, our office coordinates the adjudication of ethical complaints in administrative proceedings. All right? No, leave your phone on. We're gonna need that later here. That's a teaser. All right, so one of the things that we also do is we provide advice to you. All right, so we do strive, I mean, we're all public servants here, right? But part of our role as being a public servant is to also serve you, which again, in a circle, roundabout kind of way, serves our purpose in ensuring that, you know, government operations are carried out with the highest level of integrity. We have two main mechanisms for providing guidance that is specific to a situation for an individual. We have informal advisory opinions that we issue. This is written advice written by OIG attorneys where you provide us with a scenario and you ask us, hey, what are my ethical obligations in this situation that I'm in? And we will provide you legal advice. And we're really quick about turnaround time with that. We aim to get those responses out to you within 1 to 3 business days. The advice is specific to you and it is confidential to you. We won't share it with anybody. We won't share it with your boss. We won't share it with anyone. Now you can share it with whoever you want, right? But we keep it confidential. So the guidance that we issue, it's not binding, but if you rely on the informal guidance that we do provide, the commission, the State Ethics Commission, which serves as the adjudicating body in determining whether or not an ethical violation has occurred, they'll take that as you acting in good faith, right? You followed the guidance that we've issued. You've acted upon it, on that guidance, then you've operated in good faith. If there was any kind of subsequent, you know, ethical allegation. The second piece of advice, this, you know, as a formal advisory opinion is what it sounds like. It's a formal declaration of and a dispositive statement on ethics in a particular situation. This is a public document, right? This is considered by the State Ethics Commission in a public meeting, but they will issue conclusive dispositive guidance on the application of the Code of Ethics. Now, just a note, both our informal advisory opinions and our formal advisory opinions have to be based on a real set of circumstances. Okay, so we don't want to get into hypotheticals. As much as, you know, we're academically curious about what if in this particular situation, we won't go down some of those hypothetical roads. So let's talk about the limits of the jurisdiction for the State Code of Ethics. Are in the state's executive branch, right? Remember high school civics. And the Code of Ethics and the Office of Inspector General has jurisdiction over those state employees that make up the executive branch, as well as state appointees to commissions and boards, as well as state officers for some of the Code of Ethics provisions, and in limited circumstances, and this can come into play with contracts, individuals with a business relationship with your agency. We do not have jurisdiction over the legislative branch, legislators. We do not have jurisdiction over the courts. We do not have jurisdiction over local municipalities, city and county governments. So for you attorneys out there, it wouldn't be a CLE in ethics if we don't just acknowledge the fact that there is some professional obligations as part of your licensure, right? And I don't know if it's been a while since you took the MPRE, but it has been for a lot of us, I'm sure. But these do bear mentioning, right? be mindful that there are the rules of professional conduct. A lot of them enforce very similar types of concepts that we're going to talk about in our Indiana Code of Ethics. But again, we don't have jurisdiction. OIG doesn't have jurisdiction to enforce ethics under the rules of professional conduct. That's an entirely different scenario. Here's something that you want to pay close attention to, particularly as it relates to post-state employment scenarios, because not all of us are going to stay in state government forever, or some of us might move from one agency to another agency, and these kinds of things can come up. It could also relate to your activities as an attorney prior to your role in state government, right? If you represented clients prior to your role. So Rule 1.11 talks about special conflicts of interest for former and current government officers and employees. Sounds applicable, right? So this talks about, and I'm just going to paraphrase this, but unless you're expressly authorized by law, a lawyer who's formerly served as an employee of the government shall not represent a client or participate in a matter in which that lawyer participated in substantially and personally as that government employee. So personal and substantial participation is the bar. That's language that's used in the rules of professional responsibility, and it's language that's also used in a provision that we're going to cover in a minute here in the Code of Ethics. You should also kind of be familiar with the fact that there are rules pertaining to concurrent conflicts of interest in the rules of professional conduct. But outside of our scope to really dwell on all of those today, we're going to get back to the Indiana Code of Ethics, but I will let you know, if you didn't already, the Supreme Court Disciplinary Commission does offer a service very much like what the Inspector General offers in terms of offering informal guidance. So there's a website and it's linked at the very bottom of this page. You can go to them and ask them a question and they will issue some advisory opinion to you about the applicable rules of professional conduct. So has anybody ever availed themselves of that service yet? I was raising my hand, but I haven't. No, I'm very interested. So if you know somebody that's comfortable talking about it, I would be interested to know. So here's where the Code of Ethics are found. They're in statute at 426. 1 through 17, sections 1 through 17, and they're also promulgated under the administrative code at 42 IAC 1:1 through 1:11. They cover many different topics about what you can do as a state employee and what you can't do as a state employee, right? Or even what you can and can't do after you're finished being a state employee. And again, in alignment with the mission of the Office of Inspector General, these rules are all about preventing the abuse of power, ensuring the protection of the public trust, ensuring transparency and public confidence in state government. So these are kind of the subject matter areas. And again, I'm not going to go through all of these, but you can see they run the gamut from gifts, lots of different types of conflicts of interest, moonlighting, working outside in another job while you're maintaining state employment can present some tricky situations, ghost employment, nepotism. Let's turn our attention. You know, just as an aside, I lament the fact that I don't have any Muppet slides up here for you today, and I was looking for Jim and Terry, and I just wanted to give them a personal thank you because that was the highlight of the IoT presentation for me. And I almost wore my Muppet Babies tie today, but I'm glad I didn't. So let's turn our attention to gifts. Gifts rule provide, the gifts rule under the state code of ethics provides that you, your spouse, or your child cannot accept, cannot receive, and cannot solicit any gifts, favors, services, travel expenses, food or drink, registration fees, entertainment from a person that has a business relationship with your agency. Now, if you're involved in a contract, your agency is involved in a contract with another entity, would you say that there's a business relationship with that entity? Exactly, right? So this is how this applies and comes up. It's also, the gifts rule also does all of these things, not only for individuals with a business relationship, but also for any individual who seeks to influence your action. And one thing I would point out too, which is interesting, is it doesn't matter whether you are of the utmost integrity and could never be, swayed by the $1 million in unmarked bills that are laying on the table behind you. What matters is the other person's intent. So just going to point that out. Person with a financial interest in a contract has a business relationship with your agency. Someone that has a license or permit by the agency that you work for has a business relationship with your agency for the purposes of the gift rule. And again, I mean, you can see this, right? This rule aims to avoid the perception of impropriety or undue influence. And a note about solicitation, not only can you not solicit something from somebody that has a business relationship for yourself, you can't solicit for somebody else, right? So the gift rule technically would prohibit you from soliciting, say, from one of your vendors that has a business relationship with your agency for the purposes of donating to a charity, right? We kind of run into these situations too. Now, just to be aware that the gifts rule can be tricky to apply. And that's why we do encourage you to avail yourselves of our ability to provide you with guidance based on a specific set of circumstances that you might encounter. There are exceptions to the gifts rule. There's 8 of them. Here are the couple most common. Mementos and souvenirs. So you go to a conference, you've got vendors there. Some of those vendors work free or, are under contract with your agency, and they're offering keychains and pencils and a bowl of chocolates and that kind of thing. I always enjoy going through the vendor hall and helping myself to chocolate. Those are part of the exception based on their very nominal value, right? You start to get concerned, or you start to get into murkier waters when value can't be quantified or value is obviously not nominal, right? So there's not a bright line here as to when you cross that threshold from nominal to subject to the gifts rule and prohibited. I would just advise to err on the side of caution. Gifts from a relative or a person that you have an ongoing social relationship with. This can be tricky to apply too, right? A lot of times, and I don't know, from your experience, but working with vendors that I've worked with I've worked at the Department of Child Services, worked closely with vendors there, develop social relationships with those vendors. And this can get tricky, right? Because there's still that business relationship, and think about the reason for these rules, the appearance of impropriety. So it can be tricky. Food and drink consumed at a public meeting where more than 25 individuals are invited. There's some definition parameters about what constitutes a public meeting. So again, these can be very tricky and to apply in a fact-specific situation. Now, along with the 8 exceptions that are outlined in the code, or in the administrative code rather, the application of the gift rule can be waived by your agency. And it's not an uncommon thing it has to be in the public interest, right? Any kind of waiver of the gift rule has to be consistent with serving the public interest. So there are times when, say, somebody you contract with will pay for an employee to, pay their registration fees for a conference, maybe pay travel expenses. These could be prohibited under the gift rule. But you're saving the state a ton of money if, you can accept that. So and these things are these waivers are filed publicly. They're available on the Office of Inspector General website. If you're curious, feel free to go ahead and take a look and see what kinds of waivers agencies do issue. But if you have questions, you certainly should feel free to ask our office. Another thing that I would point out, and this is as good a place as any to point this out, is that we have in every agency a designated ethics officer. And so you can ask your agency ethics officer too for guidance if you feel comfortable. So I'm going to briefly give you a couple of questions. I want you to get on your phones if you aren't already. I know who you are. Where'd that guy go? Go to menti.com, www.menti.com. We're going to ask you a couple of questions to test your knowledge. Once you go to menti.com, enter this code, 46550649. And I'm stalling to give you time to do this, but I'm going to move on to the next code. The next slide here. All right. So, test your knowledge. Your agency regularly purchases registrations from a continuing legal education provider for CLE courses that are provided to the agency staff. One of your staff attorneys is going to be invited to present one of their sessions, and in exchange, that CLE provider is going to give them the full day's registration. So through the gifts rule, let's analyze. Is that free registration a gift? I have a yes, I have a no. We have some yeses, we have some nos. Wow, the overwhelming consensus is that this is a gift. Okay, so yes, the registration fee waiver is a gift under the gift rule. It would be appropriate to do something else about this. So moving on. What should you do if this gift was offered to you? What would you do? Would you insist on having the agency pay? Would you talk to your agency ethics officer? Seek advice from us at the Office of Inspector General, or D, don't worry about it. Nobody's paying any attention. I like it. You guys are going to the front line. Again, you don't have the rules of, chain of command and protocol don't apply here. You can go to your agency ethics officer. You can also come straight to the Office of Inspector General too for guidance. And the first answer is also appropriate. So a lot of these issues, there's way more than one correct answer. There's more than one incorrect answer too, I'm sure. Last example on the gift rule. So your agency contracts with a drug testing lab and you're out at the conference together and several of you go out for dinner and the vendor that your agency contracts with picks up the tab and you've ordered drinks and food and they just take the bill and they pay it. So, is that dinner and drinks a gift? Yes, no, I don't know. I don't know is a good answer too sometimes, just so you know. But yes, this is something that clearly feels like it might be a gift. So moving on here, what should you do? Should you chase down the server? Should you do nothing? It isn't a prohibited gift, it's fine. Should you just order dessert and another drink maybe? Or I don't know. All I know is whoever said order dessert, you're wrong. Don't. It's funny, but right, that definitely has the appearance of impropriety. And there are different ways that you can handle this, but you shouldn't just let it go, all right? So I'm going to turn it over to my colleague, Doreen Clark, who's going to get into some of the conflicts of interest related to contracts.
Thank you, Sean. So my name is Doreen Clark. I'm a staff attorney for the Indiana Office of Inspector General. And today I will be talking to you about conflicts of interest as it relates to contracts. So the conflicts of interest as it relates to contracts rule can be found in IC 4-2-6-10.5. And that rule simply states that a state employee may not knowingly have a financial interest in a contract made by any agency. And so that term financial interest, that extends to any interest that arises out of employment. So why 10.5? Why am I coming here before you to talk about Rule 10.5? Well, the answer here is very simple. This rule pertains to employees, state employees who have expressed some type of interest in working for a side job in addition to their state job, but that side job has some kind of contract with the state. So I'll give you an example of that. Let's say you have an FSSA employee, he's working his regular job. He's expressed interest in working for ABC Company, but ABC Company has a contract to render some type of good or service for the Department of Revenue. If that FSSA employee decides to work for ABC Company, knowing that there is a contract with the DOR, that's going to be a violation of 10.5. So it's important to emphasize that it doesn't have to be within your agency. It can be any agency. So there is an exception to this rule. A state employee can actually have financial interest in a contract, but they have to meet two elements, and both elements must be fulfilled. The first element is that he has to not participate in or have any official contracting responsibility for the contracting agency. And then the second element is that he has to file a written disclosure form with our office prior to the execution of the contract with that agency. It is important that that state employee does file that written disclosure form, because if you do not do that, then you would be in violation of that rule. So if you're interested in working for an employer and you're not sure whether or not that employer has a contract with the state agency, the best avenue to take is to contact your ethics officer, or you can contact us and receive an informal advisory opinion, and we will inform you as to the best steps to take from here. Okay, so the last thing that I wanted to talk to you guys about is criminal conflicts of interest. So this is a criminal statute that is in IC 35-44.1-1-4. And that basically states that public servants cannot have any pecuniary interest in any contract that is within the public service agency. So unlike 10.5, where I was talking about how you can't have a side job with any agency, this is within your agency that you are employed in. So I'll use that FSSA example again. So if you're an FSSA employee and you are working, you're interested in working for ABC Company, and ABC Company has a contract with FSSA, that company that you're employed in, that's going to trigger this statute, and it's going to lead to a lot of trouble. So this is a level 6 felony, guys. So if you're not sure as to whether or not this side employer that you're interested in working for has a contract within your own agency, the best thing to do is to avoid working for that employer altogether. But if you must work for that employer, the next avenue that I suggest you take is to seek a private attorney and get legal advice from that attorney. Okay, so this is another test your knowledge question here. pertaining to conflicts of interest related to contracts. So Sarah works at the Indiana Department of Transportation, that's INDOT, as an electronic technician two. In her role as electronic technician two, Sarah oversees maintenance of traffic signals and supervises traffic signal maintenance contracts within various counties across Indiana. Sarah owns her own side business in which she writes computer software applications and sells them to various companies. Sarah has developed a software that would help improve traffic signal development and potentially benefit INDOT. Sarah would like to form a contract with INDOT in which she will sell this software to that agency. Question is, does this scenario present a conflict of interest pertaining to contracts, and what should Sarah do? So the majority answer is correct. Yes, Sarah should seek her INDOT ethics officer for ethics advice and seek an informal advisory opinion from the OIG. This was actually a case that went before the State Ethics Commission. The individual wanted to seek a formal advisory opinion as to whether he could sell the software that he was making for INDOT to INDOT. And the State Ethics Commission said, no, you can't do that. That's a conflict of interest because you are a business, you're trying to sell, create a contract with the state agency that you're working for. So that would not only have been a 10.5 violation if this had gone forward, but this would have also been a criminal conflicts of interest issue as well. That's it. I will turn over the rest of the presentation to Mark Mader. Thank you.
When I prepared my talk, I started thinking, what would I want to know if I was sitting where you are? And believe me, I've sat where you are. How about rule number one? Get the fee up front. Or the other rule number one, the client goes to jail. Seriously though, as attorneys and state employees, we have a lot at stake. Job, pension, retirement benefits, vacation pay, etc. We don't want to be the one paying the fee up front. And we sure don't want to be the one who goes to jail. Let's talk a little bit about what could happen if we fail to follow state ethics rules. IC 42612 provides that the commission can do any of the following. One, impose a civil penalty not to exceed 3 times the value of the benefit received. 2, bar you from entering into a contract. 3, order restitution or disgorgement. 5, reprimand, suspend, or terminate your employment. 6, reprimand or recommend the impeachment of a state officer. Bet you didn't know that. 7, bar you from future state employment. And believe me, sometimes if we've submitted matters to a prosecutor, we will also file a complaint with the Ethics Commission simply because we don't want that person to ever be employed in state government again. 8, revoke your agency license or permit. 9, bar you from obtaining a license or permit issued by an agency. Revoke your registration as a lobbyist and bar you from future lobbying activity. Lawyers, these sanctions are in addition to any sanctions you might receive for violating the rules of professional responsibility from the Supreme Court Disciplinary Commission. Which now brings us to 42611, the post-employment rule. Now, the post-employment rule consists of two separate limitations, a cooling off period and a particular matter restriction. The cooling off period prevents you from accepting employment, one, as a lobbyist, which Tammy Glickman is going to cover. Two, from an employer with whom you were engaged in the negotiation or administration of a contract on behalf of any state agency and were in a position to make a discretionary decision affecting the outcome of the negotiation or the nature of the administration. Or three, from an employer for whom you made a regulatory or licensing decision that directly applied to the employer or its parent or subsidiary until a lapse of 365 days after you leave state employment. So you're barred from working for that employer for 1 year. For example, if you worked for the Alcohol and Tobacco Commission and you made a regulatory or licensing decision that directly applied to a liquor wholesaler, you would be prohibited by you would be prohibited from employment by that alcohol wholesaler for 1 year after you leave state employment. Take note, that's the rule states 1 year after leaving state employment, not 1 year after leaving the state agency for whom you made the licensing or regulatory decision. In addition, you're prohibited from accepting employment from an employer if the circumstances surrounding the hire suggests that the employer's purpose is to influence you in your capacity as a state employee. If your state employment required you to engage in the negotiation or administration of a contract on behalf of any state agency, and you were in a position to make a discretionary decision affecting the outcome of the negotiation or nature of the administration, you are prohibited from that employer for 1 year after leaving state employment. For lawyers, there is an exception. If you engaged in the negotiation or administration of a contract with attorneys representing a company and you were in a position to make a discretionary decision affecting the outcome of the negotiation or the nature of the administration, you can accept employment with the law firm that was representing that company immediately upon leaving state government and not violate the cooling off rule because your employment is with the firm, not the firm's client. Now, this leads us to the second part of the post-employment rules limitation, which is the particular matter restriction. Even though you may accept employment from the firm immediately upon leaving state government, you cannot work on any of the following 12 types of matters listed in IC 42611G or 11A. 1, an application. 2, a business transaction. 3, a claim. 4, credit, a contract. 5, a determination and 6, an enforcement proceeding. 7, an investigation. 8, a judicial proceeding. 9, a lawsuit. 10, a license. 11, an economic development project. And 12, a public works project. These are all particular matters as described in the code. The statute specifically excludes the proposal, consideration, adoption, or implementation of a rule or administrative practice or policy or practice of general application. So even if you engage with the company's lawyers in the negotiation or administration of a contract on behalf of the state agency and are in a position to make a discretionary decision affecting the outcome of the negotiation or nature of the administration and not violate the cooling off period because the contract is with the firm's client, not the firm, you can never work on that negotiation or administration for the law firm or anyone else for that matter during the life of that contract. Most particular matters have finite lives, particularly in state government. Commission reviews each referral based on the facts presented. And believe me, the facts can be rather tricky. Some contracts have provisions, not state contracts, but just as an example, that are renewed automatically, but unless canceled by either party. And you've already heard that that can't occur in state government. But what I'm telling you is be careful. Err on the side of caution. If in doubt, check with your agency's ethics officer. In analyzing if a particular matter might be forbidden, this is the way that I would go about it. Question, is this matter considered one of the 12 particular matters under IC 4211A? If the answer is no, it's okay to work on the matter. Question, was your participation in the matter for state personnel, for the state, personal and substantial? If the answer is no, it's okay to work on the matter. If the answer is maybe, the best course of action would be to ask for a formal advisory opinion from the commission to determine whether or not the participation was personal and substantial. If the commission says the participation was not personal and substantial, it's okay to work on the matter. If the answer is yes, you cannot work on the matter without a post-employment waiver. The post-employment waiver process is found at IC 42611G. 42611G provides that a state employee's appointing authority may waive application of subsection B, the cooling off period, or C, the particular matter restriction in individual cases when consistent with the public interest. Now, for matters today, I would say that most important part of that is subsection 2, which requires that the commission, you have to list whether the employee's prior job duties involve substantial decision-making authority. B, you also have to list the nature of the duties to be performed by the employee for the prospective employer. C, whether the prospective employment is likely to involve substantial contact with the employee's former agency. D, whether the prospective employment may be beneficial to the state or the public, stating specifically how. E, the extent of economic hardship to the employee if the request is denied. The waiver must be filed with and presented to the commission by the state officer or appointing authority authorized to sign a waiver. And I might add, the waiver has to be prior to accepting employment. If you've already accepted employment and now you're seeking a waiver, the appointing authority can't give it to you. Commission may conduct an administrative review of a waiver and approve a waiver only if the commission is satisfied that the information provided in subsection 2 is specifically and satisfactorily articulated. However, You can work on any new matter in which you did not personally and substantially participate. All of that brings us to IC 4269, the conflicts of interest related to decisions and votes rule. I-2469 prohibits a state employee from participating in a decision or vote or a matter related to that decision or vote if the employee has knowledge that various persons may have a financial interest in the outcome of the matter, including the state employee himself or herself, an immediate family member, a business organization in which the employee is serving as an officer, director, or employee, for any person or organization with whom the state employee is negotiating employment. The code defines financial interest to include any interest in a purchase, sale, lease, contract, opinion, or other transaction between an agency and any person or involving property or services. The term does not include an interest that is not greater than the interest of the general public. Immediate family member is defined in 42 IAC 1313 as a person's spouse, partner, housemate, or unemancipated dependent. Negotiating employment has been determined by the commission to begin when there is a back and forth exchange, such as scheduling a job interview or offer of employment. Once employment negotiation begins, you are prohibited from participating in any decision or vote or a matter related to a decision or vote in which the employee would have a financial interest. If it appears unlikely that you would participate in any decision or vote or matters related to a decision or vote, your new employer, in which your new employer would have a financial interest, you would not have a conflict of interest at this time. If this changes and you identify a potential conflict of interest during the remainder of your state employment, please note that recusal from the matter is not enough. The rule requires that you notify your state agency's appointing authority and ethics officer in writing and either seek a formal advisory opinion from the commission or file a written disclosure form in accordance with 4269's notification requirements. The disclosure form includes the proposed screen that will be in effect with respect to your interaction with your new employer for any remaining time you are employed by your state agency. If you do not accept an employment officer from your new employer, then the screen can be terminated. That's all I have for you this morning. Tammy Glickman is now going to provide you with all of the information that you always wanted to know, but were afraid to ask about executive branch lobbying.
What's the clicker? Hi, good afternoon again. First, I want to thank the Inspector General's office for allowing me to have a few minutes to talk to you about executive branch lobbying. I'm sure none of you here are like I was when I started at State Employment and didn't even know this existed, that there was such a thing as executive branch lobbying. I'm embarrassed to say that I'm pretty sure the first time I found about executive branch lobbying is when I took the job at IDOA and the commissioner said, well, now you're going to be the director of executive branch lobbying. So of course I had to brush up on it and figure out what it was and how it applies to state government. In case I don't get to it at the end, I prepared some brochures that talk about executive branch lobbying. This isn't necessarily for you as the employee. These are for lobbyists, basically, that are coming to your agency. And I'm going to talk about that a little bit here. But these are for the lobbyists. You can leave these in your lobby or anywhere where your executive branch employees are meeting with lobbyists. So they can read about it, brush up on it. And if they get a call from me that says, hey, are you familiar with registering? They'll have a little background on why they're getting a call or an email from me. They're outside. There's plenty of them. Take a nice pile for yourself. So here's a little background about executive branch lobbying. It began by executive order, and then rules were promulgated and administrative Indiana code codified it. So executive branch lobbying, I guess, is similar to legislative branch lobbying in that you have to register and there are restrictions about it. But we're members of the executive branch. And I guess why I'm so thankful that I get this opportunity to speak with you is that it's my ask for you to help me enforce the executive branch lobbying registration requirements for the state of Indiana. If you don't know about it, then you're not going to be able to bring it to the attention of the lobbyists or to bring it to the attention of me as the director. So these are some of the numbers. We did go down a little during the pandemic. There wasn't a lot of direct lobbying. Obviously, any communication is still lobbying, phone calls, emails, those sorts of things. But I know many of the lobbyists like to meet in person with members of the executive. They come in groups sometimes, and that kind of went down when none of us were in the office. But here's some of the numbers and some of the compensation that the executive branch lobbyists do here in Indiana. So what is an executive branch lobbyist? The first thing you need to know is that there is a threshold in the state of Indiana for lobbying dollars earned, and it's $1,000. So if you work for the State Teachers Association and you're going to give a call to somebody in the executive branch about some great product or some lobbying effort that you need the executive branch to have their eye on, or you're trying to influence them, and you put in 2 hours of your time and you're on salary at the, association. You may not, I don't know what your salary is going to be. People ask me that, how much do I register? If it's under $1,000 and you just did it once in the course of a calendar year, then you don't need to register. But if you hit the $1,000 as a lobbyist, then you're required to register. And again, it's important to note this is on a calendar year basis, lobbying registration. It's also important for you to know who is not an executive branch lobbyist. So a good example is, well, of course, an attorney who's representing somebody under AOPA, your agency has administrative rules, and somebody's objecting to some licensing that was, against their client's interest. That would not be lobbying. Obviously, the media, when they ask questions or do that, that's one of the exceptions. And of course, communications for the sole purpose of gathering information relating to a bid, procurement, or a public work. So those are some things that are not lobbying. So I hit on this a little bit before, why do you care? Why do you even care about executive branch lobbying? I guess you care because it not only impacts you in your agency, and of course I've asked you to help me out by letting these folks know that they're required to register, but it also impacts you because of what the Inspector General's office has just said. You may not take employment as an executive branch lobbyist for 365 days after you leave state employment. That's the revolving door rule for obvious reasons. The integrity of what we do here, and we don't want to step out the door and then begin to lobby back at the Department of Administration on behalf of my client, large tech, number 1, 2, 3, 4, who wants the next, 9.4 PeopleSoft. So these Also, this applies to your boards. That's another important point I want to make. As attorneys, sometimes we get called on to answer questions, I think, about some of our boards. Many agencies have multiple boards and commissions. It also prohibits you from serving on those unless the board is just an advisory body and not a policymaking body. So the executive branch lobbyist, we have a database. You can always contact me directly, but there is a database on our website. It's pretty old and it gets wonky. So if you ever have any questions, you can reach out to me. But if you're wondering if that big group of folks that are in the lobby of your office meeting with your commissioner or your director are registered, you can check this database and see. You can check the database and see how much everybody's making over the course of their year and reporting. And I think that's important information for us to know. So the definitions are much like the things that the Inspector General spoke to you about. What is lobbying activity? It's important for you to know what is and what isn't, but not necessarily in the particulars, because you can always reach out to me. It is a pretty easy process for the lobbyists to register. That's another point. If ever you have to get into a discussion with a lobbyist, it's only $50. You register, you put your information in there, and within 15 days, you are required to registered the information, your communication. I was at FSSA. It was in the middle of session. It was March 15th. My client is, tech company ABC. And of course, the lobbyists are required to update their accounts over the course of the year. I'm kindly working with them to enforce this a little bit better. They forget about this piece, that they're required to update it when they leave employment. They work for a, big lobbying firm, and then they leave, and then they go to another law firm and they can't access their account. These sorts of things happen, but they're required to report that according to the administrative rules. Of course, they have to file an annual report. That's how I find out how much they're earning over the course of the year and whether or not they've been registered. They have until the 15th of January to file for the previous year, and they do not roll over from year to year. That causes lobbyists some distress also. Obviously, there are enforcement abilities by IDOA, and of course, we can refer these things to the Inspector General's office, who would bring it before the State Ethics Commission. And you can be prohibited from lobbying, and there are also fines involved. And the State Ethics Commission can sanction someone as well. So these are the resources. They're on our website, the code. The lobbying manual is really helpful. Previous General Counsel Tim Grog put it together. And it's really very easy to understand if you want to direct anybody who's interested in the executive branch lobbying to that location. So that's it. If you take anything away from my little part of today's discussion, know that it exists and be curious, ask questions. And if you are concerned, you can always reach out to me and I'd be happy to communicate with anyone and inquire if they are a lobbyist and required to register. Thank you again very much.
Okay, well, that's going to conclude our presentations today. Thanks to everyone who presented and all the great information. And I want to also say thank you to Jean Marie Leisure and Celeste Croft from my office for helping put this together logistically. They did a lot of hard work on that. Up here is contact information. It's in your materials of the presenters today. So if you have follow-up questions or just need to know how to reach out to them, that's available there. I am going to, if there's people have particular questions that they just need to ask, we do still have most of our presenters here. We can take a couple of minutes to take those. So raise your hand and get them out now, and we will try to answer those. All right, looks like we don't. Thank you very much, and we'll see you next time. Thank you. Don't forget to drop off your certificates at the registration desk for CLE. Thanks, everybody.